Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions and lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning, good afternoon, good evening, good night, depending on where you are in the world. Happy Saturday. Happy college football season, friends. Thank you so much for coming to hang out with me today. Today is Saturday, August 30th, 2025. And the summer might not be over yet, but it's already college football season. And sadly, my Buffs lost their home opener last night in the final 2 minutes to Georgia Tech. Tied up. It was tied 20-20. 2 minutes to go. Colorado lost 27-20. And Deion Sanders is taking a lot of heat today for leaving. I think 2 timeouts on the table. So I'm feeling a little bit better. I'm not 100%. Listen, if you get whatever I got, I pity you. Don't get it. Don't get it. And I got to start it again tomorrow. Tomorrow I have to go do another. I get to go do another college drop off tomorrow. So I'll be gone for a couple of days. More planes. More sickness. It is what it is. What are you going to do? You're a mother. You do what you got to do, right? Right? Well, we have some good news. We have some good news today. But we'll wait for a couple more people to get in here. We have some good news on Kelsey Fitzsimmons. Finally, you guys, we get a little tiny bit of a win. A little tiny bit of a win. So that's good. Yeah, too bad the Buffs lost. But today's a big day for college football all over. Tell me what team you're rooting for. I like college football so much better than pro football. It's my thing. It's my thing. Hockey and college football. Yes. Are you guys happy to hear about anything? Welcome to the Anything But Adelson stream. Good morning. I know a lot of you guys are following that, and I couldn't commit to that trial, gavel to gavel. So we're covering it in bits and pieces, bits and bytes, megabits, megabytes. And I don't know, I guess the state rested, right? And they didn't call Charlie. So what do you think is going to happen next? How much longer is that case expected to go? How much longer is the case expected to go, the Adelson case? Does anybody know? So I guess Monday is a holiday, obviously. It's Labor Day here in the U.S. And so there's no court Monday. And I guess it starts again on Tuesday. A lot of Notre Dame fans in the chat. Wisconsin Badgers, Buckeyes, Florida, Penn State, Ohio State. All right. You guys are good. Michigan in the house. Roll Tide coming in hot. I know. I think college football is so much more exciting than the pros. I don't know. Hate on me about it. I don't care. Yeah, so the judge wants to be done by the 5th. What day is the 5th? I don't know what day it is anymore, you guys. I already told you what day it is. It's the 30th, right? So I guess that makes the 5th, I don't know, next Friday. Is Donna going to testify? I mean, if Donna testifies, we'll cover that day if you guys want to. The jailhouse daughters testified the other day. That was interesting. I did watch some of that. That was interesting. one of them was promised a new set of veneers if she would lie for Donna on the stand. They played a whole bunch of phone calls. The one morning that we did cover it for a good 4 hours, it was 4 hours of phone calls that were hard to hear. So I had to read a lot of them to you, a lot of scripts. How to read a lot of the scripts for you. Miami in the house. Miami in the house. Donna is supposed to testify. I don't know. What do you think that jury's going to do? I don't know what's going to happen. I mean, the text message that she sent to Wendy after Charlie was convicted was a bit damning. Like, we've been protecting you for years, or Charlie's been protecting you for years. You can bury me in the suit that I bought for your son's bar mitzvah. And then all of a sudden she starts looking for a visa and buys a one-way ticket to Vietnam. Her and Harvey. How did she convince Harvey to buy a one-way ticket to Vietnam? Is he dumb? He didn't know what was going on? Her handwritten script was mind-blowing. Debbie thinks they proved their case. JoJo says get Donna, then Wendy, because she's sus. I don't know. I didn't follow the other however many trials there were, so I don't really have an opinion one way or the other, and I didn't really watch it carefully, so I'll listen to what you guys have to say, but I don't really have an opinion to give you on that one yet. Maybe ever. I don't know. Is Wendy going to be next? I don't know. Seems like they're methodically going down the list of cast of characters, and they're indicting all of them, so it'll be Wendy, and then Javi, and then Javi, and then, I mean, look, it took 11 years. It took 11 years. So let's see. If Donna was arrested 2 years ago, it took them 9 years to arrest Donna. People say there's never going to be justice for John O'Keefe. I think there will be. I don't think the public is going to let John O'Keefe's murder go unsolved. I really don't. It might take 9 years. It might take 10 years. And listen, it seems like they had a lot more evidence, or more connections anyway, to get Donna Adelson than who knows what they have in John O'Keefe. But listen, as we know, the investigation was shite from the beginning in John O'Keefe's murder. So unless somebody flips, I don't know. We'll see. We'll see. Well, in other news, in the Karen Reed civil trial, Alan Jackson, Eliza Little, and another attorney have made motions to be admitted pro hoc vice in the wrongful death case of the O'Keefes against Karen the Waterfall and C.F. McCarthy's. And they're being sponsored by Damon Seligson, who is one of the civil attorneys in the Karen Reed case. I believe they were also Karen Reed's parents' attorneys, right? And in his affidavit sponsoring them, Damon Seligson said that on July 3rd, he sent notice to all of the plaintiff's attorneys in that case that is pending in Plymouth County, asking them to just agree to have them admitted pro hoc vice. And they did not receive any response since July 3rd. So now they're making a motion to the court to see if they will admit them pro hoc vice. I don't know if Alan Jackson will have a problem and Elizabeth Little based on, Judge Cannoni's little to no basis for saying that they intentionally misled the court. So I don't know if that is going to factor into whether or not this judge in this case, I think it's Daniel O'Shea, will allow them to come in pro hoc vice. I mean, it is rare. I've never seen, the first time I ever saw a judge deny a pro hoc vice application was the one for Mark Betterow. And that was by Judge Cannoni also in the Karen Reed original trial. So take that with what you will, but that's wild. So we'll see. The AJ announcement, I don't know. No, that was not I think here's what I think happened. Here's what I think happened. Hold on one second. They were going to make an announcement, and then for some reason they had to pull back on their announcement. I don't know what the announcement was yet. I don't know if something didn't get filed in time. It was not clickbait. It was not clickbait. and I don't want to go through this again 400 times about who said what to who and who should have said what to who on the show, whatever. There was going to be an announcement by Alan Jackson. It did not happen for whatever reason. The show had been planned, I think, for a while. And so sometimes that happens. Sometimes you have an announcement to make and then you can't make it for whatever reason, the timing or whatever. But in any event, they did submit a motion to be admitted, Alan, Liza, and there's a third attorney called named Caleb Mason. I don't know who that is. I think Caleb Mason. I don't want to get his name wrong. And we'll see if it's granted, and so that they can come in and work with them on the wrongful death civil claim. Here's what I want to see happen. I'm a civil litigator. I've been one for over 3 decades. And when we went over this initial lawsuit that was filed by the O'Keefes initially over a year ago, I want to say that it was filed, it was almost a year ago, because I remember they had a number of months left on the statute of limitations, which would have expired in January 2025. I think they filed it with 6 months to go. So they filed it around a year ago. And I said, if it was my case and it was my client that was sued, the first thing that I would do would be to file third-party lawsuits against everyone else that I felt, or that my client felt, was responsible for the death of John O'Keefe, because John O'Keefe was not hit by a car. And I'm assuming they had to wait and to see how, obviously, the criminal case played out before third-partying them in. And luckily, during that time, the civil case was stayed, which also would toll the statute of limitations. I'm not sure what the rules are in Massachusetts with regard to third-partying in other defendants, but let me explain it to you in the most basic of terms. Let's say I'm sitting in my car at a light, and let's say I get hit in the rear by another car. And so I sue the driver that hits me in the rear. And then the driver who hit me in the rear gets the lawsuit, and he's like, but wait a minute, that wasn't my fault. I was hit by the guy behind me, and that pushed me into Melanie's car. So then, but if I don't know that, then that person that I sued can then file what they call a third-party complaint against the person who hit him to say, oh, it wasn't me, it was him. See how that works? And then it all gets fought out. And then there's depositions and discovery and demands that are made. And that's what I said I would have done. And maybe it's not too late for them to do that. And by doing that, they can sue third party in the defendants that they think they can prove are responsible for John O'Keefe's death, and that they can do their depositions, and they will be forced to come in and defend themselves in court. Here's the problem for them. Oh, Mass Dad says the civil judge has likely never dealt with Alan Jackson, so he has no reason to dislike him. Yes, but could the plaintiff's attorney bring up what Judge Cannoni did or said in the Reed case as a reason to not let them come in pro hoc vice? I don't know. But I do know that they should be afraid of Alan Jackson and Eliza Little, because nobody knows this case better than they do. So them coming in to help is going to be very, 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 very painful for the plaintiffs. And here's the other issue with regard to the third partying in of the defendants for the third party defendants. Let's say, for example, in my opinion, they decide to file a third party complaint against Brian Higgins, Brian Albert, Jennifer McCabe, Colin Albert. All of those people would then need to hire attorneys to come in and represent them. And those attorneys will not be covered by insurance. Karen's attorneys are covered by her auto insurance company. That's why you have auto insurance. So if you get sued for a car accident, your carrier pays your attorneys. These private defendants will have to hire attorneys to come in and defend them, and it will be very, very, very expensive. They won't have insurance to cover it. And even if there could be some very tenuous argument that their homeowner's insurance should cover it, or an umbrella policy should cover it, the problem they're going to have is late notice to the carrier, because it's been over 3 years since John O'Keefe's murder. And in my opinion, I know I have a lot of claims adjusters in the chat. The carrier would disclaim for late notice and say, you never told us that there was a potential lawsuit. We're not paying. We're not going to defend you. Not to mention that intentional acts are also not covered by insurance. So, it kind of falls under the category of you better want what you wish for when you file a lawsuit. You can sue anybody for any time and any reason. Doesn't mean it's going to be successful. But if the person you sue feels like they're not responsible and someone else is, those other people who may be your friends are going to have to hire attorneys to represent them and defend them in the event that that happens. I don't know if it's going to happen here, but that would be my first move. And civil discovery is very broad, very broad. Depositions can go on for days. In New York, we don't have any limit on time limit of depositions. You could depose somebody for 3 days. And I've sat in 3-day depositions too, of very complicated expert witnesses and very complicated cases. Depositions can go on for 3 days. And it's interesting. We'll see if that's what happens. Homeowners insurance would cover you if somebody had an accident on your property. Mitchell, it's a great question. So if somebody slipped and fell by your pool and cracked their head open on the concrete patio, your homeowner's insurance will cover you. It's liability insurance. Everybody has it. If you own a home, you have to have it. It's a condition of your mortgage. If your dog attacks someone and your insurance company knows that you have a dog, because when you buy homeowners, you have to tell them you have a dog. And if you buy an umbrella, you have to tell them that you have a dog. That will cover you. If somebody, God forbid, drowns in your pool, your homeowner's insurance will cover you. But you need to notify your carrier within a reasonable period of time. And I would submit to you that 3.5 years later is not a reasonable period of time. And so, yes, if something like that had happened to John O'Keefe and it had been reported to insurance, it could have happened, but it doesn't cover murder, right? It doesn't cover an intentional act. You typically won't cover you for an assault. If you intentionally punch someone, it won't cover you for that. So insurance companies they're not your friend. They don't want to pay. They'll do anything they can not to pay. So it could get sticky. And I don't know if that's what they're going to do, but we'll see. And I don't know if they're going to file a 1983 action. That's what we thought the big announcement was going to be. Alan Jackson did say in his interview with Howie Carr that he nothing's off the table. Everything is still in play. Howie said federal or state court. And Alan just said yes. So we'll see. Maybe they were going to file their 1983 claim, and for whatever reason, it didn't get filed yet. And so they couldn't make that big announcement. And El Hutch says, yep, I'm a workers' comp claims examiner. Melanie is absolutely correct. Dun, dun, dun. Hang on. This is the last time I'm going to say this. Formerly known as Amherst Ann. Big announcement. Attorney Alan Jackson and Karen Reed will be joining us in studio. This is how it was worded. Having Alan and Karen on his show was the big announcement. Okay. If you go back and watch my show, it is timestamped very nicely for you. Howie Carr did an Instagram story that said Alan Jackson and Karen Reed are coming on my show, and I think they have a big announcement to make. And I played it, and it's on there. And it's the last time we're going to talk about it. And I'm saying the big announcement had to be, for some reason, postponed. That's it. That's all I'm saying. We don't need to go off on the side rails today about that. But I if you want to go back and watch it, I timestamped it for you. And it's there because I thought that I was going crazy too. And then I went back to the beginning of the show and I had played it at the beginning of the show, and whatever. It's just whatever. It's just whatever. It's not that big a deal. You know what is that big of a deal? Kelsey Fitzsimmons got bail and she went home and she was released to her parents. Praise be. For those of you who don't know who Kelsey Fitzsimmons is, let me tell you who Kelsey Fitzsimmons is. Kelsey Fitzsimmons is a 28-year-old North Andover police officer. She was shot in an off-duty confrontation with police at her home couple of weeks ago, she had been suffering from postpartum depression or postpartum psychosis. She was a new mom and she was on leave from North Andover PD because of her postpartum depression. She was engaged to be married to a North Andover firefighter who was the father of her baby, and they had some sort of spat in Maine over a weekend that may or may not have been their bachelorette party weekend. I'm not quite sure. Their wedding had been scheduled for October 4th of 2025. Justin, the firefighter of North Andover Fire Department, who's the father of the baby who was 4 months old at the time, had been very supportive of Kelsey and her struggles with her mental health and her postpartum. And she also had depression during her pregnancy, so it wasn't just a postpartum. He'd been very supportive of her, but after whatever happened between them in Maine, he went and got a restraining order against her, and in order to take the baby away from her. He claimed she was a danger to herself and to the baby, and it was an ex parte thing where he went in without her and got this order. And while she was sitting at home feeding her baby on the couch, 3 North Andover police officers, all men, all co-workers of Kelsey, knocked on her door to take her baby away and serve her with this restraining order. It was a 209A order, which in Massachusetts is a DV type restraining order. Kelsey handed her baby over. What happens next is in dispute. Kelsey hands her baby over to the 3 officers. They don't come with a mental health counselor. They don't come with CPS or DCF or whatever they call it in Massachusetts. And she says, my guns are in the basement. I don't really know what happened. What happens next is in dispute. She says, I need to go upstairs and get some things for the baby. Put together some clothes. She goes upstairs and one of the officers goes with her. He's a 20-year veteran on the force. He was maybe her partner. They were good friends. And 1 year prior to this day, Kelsey and this officer had responded to a call. Kelsey was pregnant at the time, in which a new mother took her own life and took her baby's life in front of Kelsey and this officer. Okay, there's the backstory. What happened next is Kelsey's story is she took her firearm out, wanted to take her own life because she saw her whole life being taken from her. Her baby was being taken from her, and she wanted to take her life in that moment, pointed her gun at herself. The other officer, her buddy, says she pointed the gun at me and she threatened to kill me. And so I pulled out my gun and I shot her in the chest. And he did. He shot her in the chest. She was airlifted to a Boston hospital. She was fighting for her life. She underwent at least 3 major surgeries. And then Kelsey was charged with attempted murder with a firearm and some other assault charges. She was arraigned in early August from her hospital bed. She's being represented by Tim Bradl. There were no body cams because North Andover PD doesn't use body cams. So in early August, Kelsey Fitzsimmons was arraigned from her hospital bed on charges of armed assault with intent to murder and 2 counts of assault with a dangerous weapon. Because I think, if I recall correctly, maybe they're saying she pulled the trigger once and then she went to rack it to put another round in there or something. I'm not a gun person. I don't know the terminology, so cut me a little bit of slack. Kelsey was shot once in her chest, like I said, by this 20-year veteran who also obviously had some lingering PTSD from the incident that they had both responded to a year prior. That happened on June 30th around 6 p.m. He shoots her in the chest. Essex County is the district attorney. Paul Tucker, is Essex County DA, and they decide to charge her or to go to the grand jury with charges of attempted murder with a weapon and the 2 counts of assault. There's more to the story, which I'm not getting into right now, but I've done a couple of other shows on this. So if you want all the rest of the details, I'll link those shows below so you can go back. Tim Bradl gave a statement from Kelsey. We read that once during a show. And then he read a statement that Kelsey gave. And she said, I'm in trouble and I have a gunshot wound to my chest because in that awful, isolated moment, I no longer had the will to live. But yesterday, we found out the grand jury did not indict Kelsey on the attempted murder charge. That, my friends, in Massachusetts is a huge win for Kelsey. And I want to thank you for talking about this story. And I want to thank you for being interested in this story. And I want to thank you for donating to Kelsey's campaign, the Give, Send, Go, to help her rebuild her life and get through this. And you guys are so amazing and so generous. And I don't know if it had anything to do with the no true bill from the grand jury, but they did not indict her on the attempted murder charges. And that in and of itself is a huge win. Let's go to the coverage. I was trying to cover this. I think it was on Thursday. And when I went on the Zoom to cover it, it was on for a probable cause hearing. And it said, you know, any unauthorized recording of this will get you in trouble and blah, 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 blah. And I didn't want to get in trouble. I didn't want us to get in trouble because you know how certain people like to report us for now streaming things in Massachusetts that are on Zoom. Luckily, the WCVB did have a camera there. And then we're going to watch Tim Bradl did a statement outside of court. It's about 7 minutes long. And we're going to listen to him. We're going to tell you what she is ultimately charged with. We're going to get to that in a second. Let's watch this short piece from WCVB from yesterday.
Now, the North Andover police officer shot by one of her colleagues has been granted bail. A grand jury rejected a charge of armed assault with intent to murder against Kelsey Fitzsimmons, indicting her only on a charge of assault with a dangerous weapon. That comes with a...
The only charge is assault with a dangerous weapon. You guys are awesome.
Maximum sentence of 5 years if convicted. Fitzsimmons pleaded not guilty to that charge this afternoon. A fellow officer shot her in the chest back in June as police served a restraining order on behalf of the father of her newborn. They say she pulled a gun on officers. Her lawyer denies that and says she's been getting the help she needs for postpartum depression.
A delay there, but
so it looks like she's out of the hospital. She appeared in court. She looks good. Thank God. She could have been killed. She's looking at one charge of assault with a deadly weapon, and she's looking at now 5 years in jail, as opposed to the attempted murder charge, which probably was 25 to life. I'm not quite sure. Let me know how that volume booster is working on the YouTube videos, eh? Eh? And she looks good. But you know how rare it is for a grand jury not to indict. You know how rare it is. Because a grand jury will indict a ham sandwich. They indicted Karen Reed on second-degree murder charges, and John O'Keefe wasn't even hit by a car. Hold on. And so whatever evidence they had was not enough to convince a grand jury. And I don't know if anybody on the grand jury had heard any of the coverage on Kelsey Fitzsimmons. They're not supposed to have. Or if what they had was so thin that they felt like they couldn't indict her, because usually, you know, police officers are given very high levels of credibility. And a grand jury is a one-sided proceeding. It is only the prosecution's case. The defendant doesn't participate. The defense attorney doesn't participate. Oftentimes, when they convene a grand jury, the defendant doesn't even know it's happening. And so it's all one-sided. And there's no judge there. And so the prosecution just presents its case the way they want to. And you know, from all of the motions that we went through in the Karen Reed case about, you know, false information presented to the grand jury, you know, the kind of things that Adam Lally presented to the grand jury and, you know, the things they failed to present and the things that they failed to disclose about Proctor's relationship with the people in 34 Fairview. They do whatever they want. They get the indictment. And this is a huge win for Massachusetts, for justice in Massachusetts, a huge win for Kelsey Fitzsimmons, a huge win for Tim Bradl. In limine, I just told you, Guy, it's Essex. Let me just see if I can find it again. You're asking who the DA is. It is in Essex County, and it is Paul Tucker is the Essex County DA. Paul Tucker. I don't know a lot about him. Any of you guys from Essex County? I don't know. Right. Pierce says cops' credibility may be less than stellar in Massachusetts right now. Exactly. Yeah, they didn't say the details, but we've covered that before. They didn't say the details on that little piece, right? Because, you know, the media only reports half of it. If you want your real news, come to YouTube because we're going to tell you all of it because we have the time. They have 3 minutes and they want to report what they want to report. And Will is here. Hi, Glare. He says all men should educate themselves on PPD in order to understand these cases better. Yes. Praise be. Praise be. And, you know, a lot of people think it was a play by the baby daddy. I hate that term because I find it derogatory, but in this case, I'm going to use it. No, to get the baby away from her, you know, and listen, I wasn't there. I don't know what happened, but if a grand jury didn't believe it, it's saying something, right? Thank you, Will. And I agree with you 100%. ShamWow says, the quote of the year, you lost. Karen is amazing. I can't wait to see who's first to dance in the frying pan. This is going to be the case that keeps on giving, I think. The murder of John O'Keefe. I think it's going to keep on giving for a long time, in my opinion. No love, the traveling trooper. Happy Saturday. Thank you. I'm not really feeling 100%, but I'm going to do my best today. Thank you so much. That whatever this thing is that's out there, it's long and it's it's debilitating. Apparently the C19, I don't know if it's still out there, a different variant. They're saying it's out there. Don't put it in the chat, please. YouTube hates it, hates that word. But I was on 3 flights last week, and I'm sure that's where it came from, and I'll be on another one tomorrow. We do what we do because we must. Thank you. Hit the like button, everybody. Thank you, Angelique, for tuning in from South Africa. Yes, Emily C., I will allow it. Can we take a moment for Bradl's scruffy beard? Absolutely. He's so passionate. He's so passionate about what he does for his clients. He's so passionate about the First Amendment. He is so passionate about the Constitution. He is so passionate about his clients' rights. And also, can we just take a moment and forgive me because I can't remember his paralegal's name. She's right here in the white top behind him. She's always there. Sunglasses on point. Beautiful. Silver hair. She's stunning. And she's Tim Bradl's right hand. Somebody tell me her name again, and I forget her name. She's amazing. I knew her last name. I don't know if I knew her first name. Is her name Courtney? But she's stunning. I just want to say, we can talk about his beard too, but she is absolutely stunning. And listen, there is nothing when you're an attorney to have the loyalty and dedication and hard work of an amazing paralegal. And my paralegal was with me for decades. I mean, once you have a good one, you cannot let them go. And you pay them and you pay them and you pay them because without them, you are a dead person. Courtney. Yeah. Her name's Courtney. Okay. All right, Courtney. I forget her last name, but I would call her Ms. So-and-so, but she's on point. She's fire. Let's listen to Tim Bradl's statement after Thursday's arraignment, because he's got a lot to say about the grand jury. Tim Bradl is everything. Glare, is it me? Do you have a crush on him too? No, he's very married, very happily married, I'm sure. But He's everything. And I love his passion. If you need an advocate and you need somebody to fight for you, he's your guy, man. He's your guy. He'll go to the mat for you. I can't say enough good things about him. All right, here we go. She's prettier in person, says Cheech. Is that even possible? Cheech in the house. Cheech in the house.
We'll get to everybody, so don't worry. Who wants to go first?
I guess one of the main things we were interested in is you said something about the wrecking ball to the case. The grand jury only came back with a very less significant charge.
Yes, they initially, the theory of the government's case here was that Kelsey intended to murder a cop, which is outrageous and completely ridiculous of an assertion. And here, thankfully, the Essex County grand jury, and Kelsey's extremely grateful to that body for looking at the case in a realistic way. They found that their appropriate charge here was one count of assault with a dangerous weapon, which involves the apparent display of a weapon to cause someone to be placed in fear. A very, very low bar. And that's all they came back with, was that one charge. And if you look at the sentencing guidelines, she's in a position where she could very likely get a probationary sentence on this if she were guilty of it, which she is not. But the playing field has been radically shaved down. It's just really a totally different case now.
So he's saying a max of 5 years, but based on all of the sentencing guidelines, she would be entitled to probation if she was guilty, but she's not guilty. So it'll be interesting to see what happens with this. If she takes a plea, if they offer her something with no jail time and she just wants to put it behind her. But, taking a plea also could affect her custody issues, and she wants her baby. So we'll see what happens. Yeah, Courtney's got 2 phones in her hands because that's how hard she's working, right? I know. To Making It Count says, even with the grand jury loss, the county will move forward with these charges. Seriously? Oh, yeah. Maybe.
It seems like we're seeing a lot of these cases in recent times with the postpartum. Is she just having some issues that you made the argument today, so she can continue on trying to get some resolve to that?
Yeah, I mean, postpartum depression, one of the most common afflictions that a woman could have, giving birth, having a baby. It's a transient condition. That's the biggest word of the day on that, is that our experts and the Mass General experts recognize that postpartum depression is a transient condition. That's gone. She's fine. She needs her baby back. She's never been heard in a court. The only body that's heard any evidence is the grand jury. And even there was no cross-examination. And they still put the brakes on this. They still said this is at best, as a matter of probable cause, the lowest standard in the law, the lowest hanging fruit, that at best this is an assault. And it's just a completely different case. And like I said, the grand jury took a wrecking ball and destroyed the Commonwealth's case and completely rejected their theory that this was any sort of an attempted murder type scenario. This is a woman who was suffering from an affliction, who, based on words on a piece of paper, had 3 policemen come to her house and take her 5-month-old baby. A woman who's in the grips of postpartum depression, who was just scheduled to go back to work at the police department, was cleared, had her firearms given back, and her whole world was taken away from her because a guy went to the probate court right over there, filled out a piece of paper with full of self-serving allegations, and got her baby. So that's
a couple of important things to point out. Number one, there was no cross-examination because, like I told you, the defendant and the defense attorney does not participate in the grand jury. Another important distinction: grand juries only need to find probable cause, right? The standard at a criminal trial, is beyond a reasonable doubt to convict, but a grand jury only needs to find probable cause to indict on the charge. They couldn't even find probable cause on the attempted murder charge, and that's why they only found probable cause in the assault, and he thinks it's going to get kicked out. I think he's also another, you can always tell that Tim Bradl's also got another, I don't want to say agenda because it gives it kind of a derogatory term, but he's got other motives here in that he wants to see this law changed. He wants to see this procedure changed. He doesn't think that a guy like Justin should be able to go into court without Kelsey being able to tell her side and have her baby taken away. I mean, should she have been served with notice? If it was an emergency type thing, should there have something needs to change? And you can tell that he is a catalyst for change. He wants a lot of these things to change. He wants, journalistic privilege to be a thing in Massachusetts. It is a thing in almost every other state. Okay. New York and California, among two of the strongest, journalistic privilege and journalistic shield statutes in the country. There are only only a handful of states that do not allow journalists to have rights and a privilege, and Massachusetts is one of them. And that is why you see what's going on with Aidan Carney. And that is why you saw what went on with Gretchen Voss having to turn over her notes and stuff like that. It's a real slippery slope for journalists in Massachusetts. So when you don't see the reporters reporting on stuff, maybe that's part of the reason why too. And you can see that Bradl sees the bigger picture here. He's a catalyst for change. He's been doing this for a long time. And he's mad as hell and he doesn't want to take it anymore. Right? Good for him.
That's what we're dealing with here.
And
Unimaginable.
What do you make of the judge's order today? Obviously, she's going to be able to go home, get out of prison, get out of jail. Is that sort of a step in the right direction?
Yes, the case is going in the right direction, and we appreciate Judge McCarthy's attention to the case. I think that she is being extremely cautious with the amount of conditions that she put on the case, but we will endeavor to comply with every condition she wishes, and we're committed. Kelsey is very committed to showing this court, showing the judge that she's fine, that she's in control, that she's not a danger. The only thing that's been aggravating her postpartum is having her baby taken away, being on the receiving end of these self-serving allegations, and then being charged with a heinous crime that ultimately was rejected by the grand jury. So,
not to mention being on the receiving end of a bullet to the chest by her buddy, who's a 20-year veteran and undergoing 3 surgeries to save her life. Just saying.
we're now going in the right direction here. We're very optimistic that this case is going to get dealt with in the appropriate way. And for the short term, we respect the judge's ruling. We're happy to get these conditions in place, and we're going to show the court that this is not a problem for Kelsey Fitzsimmons. She's a cop. She's a CO, former CO. She's not some criminal who needs to be clamped down. And she's going to show that to the court, that she's going to handle these conditions, and she's going to do just fine.
When will Kelsey be released to her family?
Well, I think that through some Herculean efforts to get the court to get all these things in place, I think it's going to be tomorrow. So we're going to be very happy about that date.
Well, parents put a lot on the line. The judge had them swearing. Do they want to say anything about their daughter?
Mom and dad and
He said her parents put a lot on the line. They had to be sworn in and stuff like that. So I'm imagining what happened during this hearing was that the judge wanted to hear from the parents that, yes, you're going to supervise her. You're going to take her in. She's going to be with you. You're going to be watching her. I don't know if there's any conditions around the baby. I don't have a copy of the conditions for the bail. If I can get them, we'll go over them. Some of them may be confidential. I don't know. People are saying they think Tim Bradl should run for DA. I'll tell you, he probably doesn't want to take the pay cut. I'm sure that he does not want to take the pay cut. But who knows? I can't speak for him. And so the parents had to get up and they had to be sworn in. The judge asked them questions. If I release her on bail, I'm imagining this is what happened. If I release her on bail in your custody, are you going to watch out for her? make sure she shows up to court, whatever the conditions were.
Stepdad are wonderful, and they have put so much into this, and the families put so much effort into this. And I was just saying to them inside that when you have a great family behind you in court, literally they're behind you in court, that makes my job so much easier to say, Your Honor, look at this great family that's going to step up and make this right. And I think Judge McCarthy would agree that, you know, it makes a huge difference that she can see this family, and they stepped up in every way she asked, and they're going to make sure this is a success. We're not in any way concerned about that.
And there is a hearing coming up on the restraining order. What are you hoping happens there?
So we're going to assess our options on that. We have to look at that hearing in light of this order today, and we haven't made any decisions yet, but we're going to do everything we can to reunite Kelsey with her baby when we can get the judge here to look at the case anew and figure out that issue. So it's in the works.
So from what he's saying, I'm reading between the lines, and I'm thinking she's not allowed to see her baby right now because of that outstanding restraining order that the judge in, I think it was Lawrence District Court. I don't know. I have to go back and look at my notes. Granted. Kind of scary that can happen, right?
And it sounds like you were trying to fight her on that 58A dangerousness finding. Why was that an important?
Well, you know, it's just a step that we felt the judge didn't need to go that far. There are other provisions in the bail statute where someone can agree to terms of release. The court is empowered to make certain terms of release on its own. So we just felt that it wasn't necessary to go to that level of making such a declaration. And we'll have to see where that goes in the future. But we're optimistic that all those issues will be ironed out in the short term. And for now, obviously, we're going to do everything we can to comply with all these provisions.
Thank you.
Thanks, guys.
Thank you.
Oh, that's my other favorite thing that I was going to show you today. Hold on, I'm going to save that for later. So that's amazing news. That's amazing news. The grand jury did not indict her on the attempted murder charges because Mass Dad, 25 to life. What could it have been? Hi, Nurse Kim is here. I love you, Nurse Kim. Love you. Earbuds heading into the grocery store. I do that all the time. I'm always on my earbuds in the grocery store listening to you or one of my other friends in the chat, like Will. I know. It keeps me going. You guys keep me going the same way I keep you going. So thank you for that. Oh, Mama Bess has been here for a whole year since the Maya trial. Wow. Thanks for being here. The child's 2 years old. We just turned 2 in July. And the Maya trial was one of the first things that we covered. And she says, don't ever change. Thank you so much. Father Smith said, so there was some sort of DV incident, in quotes, in Maine. And the firefighter father left the baby with mom, then turned tail, ran home, and filed an ex parte for a protective order. Yep. Yes, that is exactly what happened. To making it count, says Massachusetts has been on the map for wrongdoings for a long while. This is a new era. Karen Reed, Turtle Boy, Kelsey, Fitzsimmons, Yannetti, Bradl, the people are being heard and change is a-coming. From your mouth to God's ears, praise be. New Hampshire woman, thank you for your 5. We need better mental health help, training, and understanding. I agree with you. I agree with you. Thank you so much, Jen's Tooth, for buying me a latte, even though she's on vacation in Seattle. Thank you so very much. I need all the tea I can get at this point. And Tracy says, might you be at the Wilbur on the 12th? What's at the Wilbur on the 12th? Thanks for being with me for 18 months, Tracy. You're amazing. Thank you. I never say where I'm going to be. I say where I've been, usually. Usually when I post something, it's where I've been. There's a lot of crazy people out there. A lot of crazy people out there. Many of them are in Massachusetts. At least the ones who hate me. Nobody hates me outside of Massachusetts. That's not open season. It's a chat right now. Okay, so there's that. I know, I'm just kidding. I'm just kidding. I know what's happening. Let's go back to Jen's tooth always cracks me up, says Letteros by Bettero. Who told you that, Jessica? It's been said that I'm going to be there. Who said that? Who said that, Jessica Fritz? Tell me who said that, so I can scold them. I want to know who said that. I'm not moving on until I know who said that. Father Smith says, Angela, I think there's some more information needs to be disclosed before we can really know. But they were going to be married. Why didn't he call her parents if he was so worried? Yeah, great point. Great point. I don't know where the baby is. I don't know if the baby is in the father's custody right now. I don't think the baby would be put into the system with a father. Yeah, if the father is not a danger and the father is working. You think Turtle Boy said I was going to be there? Do you think he's trying to manifest it? Do you think he's trying to manifest it? Turtle Boy and Auntie Jimmy said that on a presentation? Was it on a YouTube presentation? Do I have confirmation of that? I don't know. I don't know about that. Lola the good dog. How can a judge grant a restraining order without hearing from both parties? Also, I think your body is telling you shouldn't have left California, so you must come back. I think you're right. I think you're right. Because when I was there and I was streaming, I said, I don't want to leave. I do not want to leave this place. And I was perfectly healthy. I was perfectly healthy in the South Bay. And let me tell you something else. California just makes you want to be healthy. This is what it was like when I went to college and law school in Colorado. Every day is beautiful. Every day is sunny. Even when it's snowing, it's sunny out. Even in the spring, girls are skiing in bikinis because that's how nice the weather is. Not me, but some girls were skiing in bikinis. And it makes you want to wake up, and it makes you, the sun makes me happy. All right. Seasonal affective disorder is a real thing. And I go outside today and it's a beautiful day here in New York. It's beautiful. It's like mid 70s, no humidity for the first time all summer. And all of a sudden it's going to be sweater weather. I'm not ready for sweater weather. I am not ready for sweater weather. The summer is not over until I say it's over. And California makes me happy. It does. Thank you. But a restraining order is usually always granted ex parte. This is different though. They wanted to take her baby away. We saw Chris Albert, or we heard about Chris Albert going in and trying to get a restraining order on Aiden Carney. They didn't notify Aiden Carney that he was coming. They notified him after the fact, and somebody got fired because of that, allegedly, because allegedly gave him documents that may not even be true. We also know that Jennifer McCabe went in there and tried to get a restraining order against Aiden Carney. Denied, but it's usually done ex parte, so that's not unusual. What is unusual is that they agreed to take the baby away ex parte. That is a separate issue. And not being fully familiar with the system in Massachusetts, I don't know if that's a different order. I don't know if it. So it's a whole thing. Oh, KJ says Auntie Deb and Turtle Boy said it. I think they are using your name to sell tickets. What? KJ, I don't know if is that true. But anybody buy a ticket because of me? I don't think so. First of all, I think everyone should go to the show because I think it's going to be a lot of fun. And how cool it's going to be like a big party. It's going to be like a big party with everybody who is, involved, who thinks Karen Reed, John O'Keefe did not get hit by cars in the same room, and also, fans of Mark Better said it. He would never. Hold on. Thank you, Lola, the good dog, for your 10 spot. Oh, Pure Duckery said if Melanie goes, I'll buy a ticket. Oh, okay. All right. What's my profits? Do I get a piece of the proceeds? Oh, here's something funny. So I get an email yesterday from the Daily Mail. And the Daily Mail sends me an email saying, we'd like to use a portion of your video on an Alan Jackson statement on our website, and we will credit you and link it back to your channel. So I'm thinking, I didn't know if it was like wait. And then I was thinking, I got confused because I was like, oh, is it I was thinking the David Yannetti and Bob Alessi interview that I did with them. And so I click on the link that they sent me of my show, and it was me watching the Howie Carr interview with you. I was like, how slimy. I didn't respond, but how about you ask Howie Carr? It's his content. It's me talking about his content, but my feeling is they wanted to go around Howie Carr, or they asked Howie if they could use it. He said no, so they decided to come to me. Oh yeah, hey, just let me give you the use of my content in perpetuity forever for free. Go on with your bad self, Daily Mail. No, the answer is no. You don't have permission to use it. Because you need to ask Howie. Ridiculous, right? Sounds like the chat is trying to manifest it. What? Faces of Leah. Turtle Boy has said it a few times because I'll be there. And I was excited when he said that you'll be there. Hi, Leah. I haven't spoken to him about it. So, yeah, I said I didn't respond to the Daily Mail, but they do not have, if you're watching Daily Mail, you do not have my permission to use my content. So there. It's so funny how these like big publications who have tons of money just want to just take stuff and use it for free. And like, here's our terms and conditions, and the terms and conditions are 7,000 pages long. And it's like, we get to use your content and your likeness forever and ever and ever and ever with no compensation to you. And no, well, they said they'll give me credit, but who cares? And then who knows? Like, do they pick a clip that that I say like no? How about no? How about just no? Okay. Moving on. Let's talk about Kylee Monteiro, because Kylee Monteiro is a very, very tragic and sad story. And her funeral arrangements have been posted and it is public. And her family has invited anybody who wants to go to her funeral. Oh, Sham, wow, US Open, have I been there? Any stories? Oh yeah, my family has a box and we've had a box for 100 years. 100 years. You have to actually pass those tickets down through your family when you have a box at the US Open this year. I haven't been, but yes, for years and years and years. I've been going since I was a kid. We're talking about the US Open tennis now. And I've met several people there, including Hoda Kotb, who's very, very, very nice. And yeah, a lot of funny stories. A lot of, they have a signature drink at the US Open. For those of you who are not familiar, it is called the Honey Deuce. I'm going to tell you what's in it. It's been sponsored by Grey Goose for the Honey Deuce, like DEUC, like the tennis term. The Honey Deuce it is sponsored by Grey Goose and has been for many, 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 many years. And it's the official cocktail of the US Open tournament. And it is made with Grey Goose, lemonade, and raspberry liqueur, and garnished with honeydew melon balls. And let me tell you what, they go down easy and they're delicious. And you get to keep the cup. And I can't even tell you how many of these cups I have in my my kitchen cabinets. And I would collect them from every year. And I probably have ones from, I don't know, 15 years ago. They don't survive very well in the dishwasher, but the honey juice is good. And if you know, you know, and it's delicious. And I remember during the panty, there were places where they would deliver to your house the honey juice package so that you too could make a honey juice at home while you were watching the tennis. And so it's a lot of fun. It's always a good time. And I heard they're charging like $5,000 per day to park close to the stadium this year. Like, it's insane. It's insane. It might be more than $20 at this point, Cherie. Is it $20? Because it might be more. Because if you go to like Madison Square Garden and you buy like a drink, it's like $40. So I don't know. I don't know. Oh, here Lady Zelda says, hi, Lady Zelda Kelly. I'm building my own EVP app. We'll let you know when I roll it out and maybe you can come on. Oh, come on. Thanks, Zelda. I would love to. Thank you for your super chat. Thank you for your super chat. All right, Kylee Monteiro. I have the arraignment pulled up of that alleged monster, Gregory Groom, who allegedly confessed to allegedly murdering Kylee Monteiro. And for those of you who don't know about Kylee, let me catch you up on it a little bit. There was a vigil held last Saturday, and a lot of people showed up. And I don't know if any of you went. Did any of you go to the candlelight vigil for Kylee Monteiro? Kylee Monteiro was I thought she was 22. It says here, Kylee Monteiro was a recent high school graduate. She was 11 weeks pregnant. She was reported missing on August 7th, or she had been missing since August 7th, 2025. 11 weeks pregnant. She was last seen in the area of Country Street in Rehobeth, Mass, according to the police. I don't know. Christina, I don't know. Somebody named Christina says she's blocked again in the chat. Mods, I don't know anything about it. If somebody can reach out, if you blocked Christina. I don't, YouTube is having issues. They're blocking people. And I'm sorry if you're going through withdrawals and not being able to chat. I don't have a staff to handle my emails. And so I handle them. But I can tell you that if blocking is going on, it's only because there's been something egregious. And I don't know. Or if YouTube is going rogue and doing it on their own, I have no idea. Gregory Groom, Monteiro's ex-boyfriend, was arrested a week ago, Tuesday, and charged with murder after he allegedly confessed to killing Kylee Monteiro that day, or this says last week, but this article is from a couple days ago. He's being prosecuted in Bristol County. On August 8th, Gregory Groom had contacted the police saying that his girlfriend was missing and reporting that she had been at his house. She was looking for a place to stay. They got into an argument and that she ultimately left his residence. Prosecutors said. Groom further said that she hadn't been seen or heard from since, according to prosecutors. After friends and family hadn't heard from Monteiro, police visited Groom's residence and began an investigation. Groom told investigators that Monteiro was 11 weeks pregnant and had told him that he was the unborn child's father, according to prosecutors. He further said that on August 6th, the day before Kylee disappeared, she had left a residential program. This is the girl from Bethesda House, yeah. And took a ride share to his house and was looking to stay with him. Groom said his argument with Monteiro was about whether or not he would allow her to stay on his property, according to prosecutors. Last week, and this was a week ago, so 2 weeks ago, Monteiro's older sister, Faith, told ABC News that her younger sibling had been living at a homeless shelter for pregnant women in Pembroke, Massachusetts. The Bethesda House, right? For the past few weeks, because she and Groom's relationship was on and off at the time, and they had been experiencing domestic issues, including a physical altercation that allegedly occurred the night before she disappeared. Jess Machado has been doing an expose on this Bethesda House and the horror stories of other women who have been kicked out of this place, like in the middle of the night with a very young baby with nowhere to go in the cold, driven to a parking lot and dropped off there. Check out Jess Machado's socials for that. I don't know if it lives on YouTube or Twitter or both. And yes, I'm always going to call Twitter. I just can't get on board with the name change. Sorry. Not sorry. Investigators learned from Faith, the sister of Kylee, that the night she arrived at Gregory's house, or his grandparents' house, some people are saying, on 25 acres, by the way, Kylee texted her sister saying that Groom threw me on the ground and pulled my hair and strangled me. And then she said to her sister via text, "My phone is at 4%, and if I die, it was Greg." The family tried to get in touch with Greg to move her to a safer location, but she replied that she was attempting to continue to stay at his house. Officials conducted a search of Groom's, or his grandparents, some people are saying, 25-acre property on August 14th, but nothing of significance was found. That was August 14th. Then on Tuesday, which would have been the Tuesday after the 14th, Groom reported to police for another interview and allegedly admitted that on August 6th, he had gotten into an argument with Kylee, during which he pushed her, she fell backwards and hit her head, prosecutors said. Carol Ann, I could see your cupcake. It's yellow. Maybe your screen is light and you can't see it, but I can see your cupcake, girl. You have a yellow cupcake. When Kylee attempted to contact another individual, Groom allegedly said that he told her that he would knock her cell phone out of her hand, according to prosecutors. Investigators continued to press Greg on Kylie's whereabouts and informed him that they were granted a search warrant for his residence. But again, I think it's the grandparents' residence. I'm not sure that he owned the 25 acres and that they were prepared to search his property and dig if necessary. And at that point, Greg started to draw a rudimentary map showing a shed on his property where he was known to stay, it says in quotes. So maybe he was living in the shed on his grandparents' property, where he allegedly said the argument between him and Kylee took place. He allegedly confessed that he stabbed Kylee twice in the neck and once in the chest, and that the stab wound in the chest broke off the knife's blade, prosecutors said. Based on that stabbing, Ms. Monteiro was deceased. Groom allegedly told prosecutors that he then spent several hours digging a hole in the woods approximately 20 yards from where he stabbed her, and then pushed her body into a hole and covered it up after sunrise. After Groom's alleged confession, officers went to his property and found a large pile of brush with cut down trees in the woods, approximately 5 feet underneath this area. A body consistent with Kylee Monteiro was discovered. Along with the murder charge, Groom has also been charged with assault and battery on a pregnant victim, assault and battery on a family or household member, and aggravated intimidation of a witness, juror, police, or court official, prosecutors said. This is in Bristol County, and the district attorney there is Thomas Quinn. He told reporters after the arraignment that it is still too early to determine the motive for this murder, but the investigation will continue. Groom is being held without bail, and a probable cause hearing is set for September 10th. Let's watch the arraignment together. And again, this is in Taunton District Court. And here is Gregory Groom in his first court appearance in Taunton.
Gregory Groom. Sir, on docket 251816, on or about the date of August 6, 2025, in the town of Rehobeth, been charged with murder, assault and battery on a pregnant victim, aggravated intimidation of a witness, juror, police, or court official, and assault and battery on a family or household member. A not guilty will enter. You have the right to an attorney. Would you like to sign a waiver and represent yourself, retain private counsel, or see whether you qualify for court appointed, sir?
My name is Elliot Levine. I was contacted by CPCS to represent.
Now the volume is a little loud. Hold on. Let's see if I can fix it. Too loud. Can't ever hear it. Hold on. It's better than not being able to hear it at all.
We'll point to you to
Well, then that's going to be, then now you can't hear it, right? Hold on. I'm not a cupcake, you guys. I'm just not a cupcake. I'm really, and the cupcake is also not feeling good.
Commonwealth. Good morning, Your Honor. Jason Mohan for the Commonwealth. Based on the charge of murder, the Commonwealth is asking that Your Honor hold the defendant without bail. This incident stems from the recovery of a body last evening. The incident started on August 8th when this defendant, Gregory Groom, contacted the Rehobeth Police Department to indicate that his ex-girlfriend, identified as 18-year-old Kylee Monteiro, was missing. Mr. Groom reported that Miss Monteiro was at his house, that she was looking for a place to stay. They got into an argument, and that she ultimately left his residence walking down the driveway, and she hadn't been seen or heard from since. Miss Monteiro was known to be very active on social media, and he hadn't heard from her.
Look at the court officer standing behind, or maybe he's a corrections officer, I'm not quite sure, but well, first of all, let's just talk about him for a second, because his uniform is on point. He is well pressed. He is looking sharp. And he is within 3 inches of this guy, Gregory Groom. He is not going to give this guy an inch. This guy looks strung out, Groom, and scary. Oh, I'm sorry about our loss last night. CU Buffs are in. Not a great start to the season, but we coming, girl. We coming. We coming. He's a court officer. And he is not letting this guy get away. Take that back just a little scooch. Thank them for their service. Oh, another thing to point out, Kelsey Fitzsimmons was a corrections officer before she went to the police academy to become a police officer with North Andover PD. So she's tough. All right, here you go.
She ultimately left his residence walking down the driveway, and she hadn't been seen or heard from since. Miss Monteiro was known to be very active on social media, and he hadn't heard from her, neither had her friends or family, on any social media in the following days. When Mr. Groom reported her missing, Rehobeth police responded to the scene and took a report, and then began an investigation. In the upcoming days, when Miss Monteiro failed to update any of her social media accounts, the police began to continue in their investigation and ultimately brought Mr. Groom in for an interview. Mr. Groom reported that Miss Monteiro was approximately 11 weeks pregnant, and she told him that he was the father of the baby, that on August 6th, she had left a residential program and took a rideshare to his house. She was looking to stay with him, and an argument ensued about whether or not he would allow her to stay on his property. When the police began to question him and other family members, they learned from Miss Monteiro's sister that on August 6th, when she had arrived at his house, that there was an altercation between Mr. Groom and Miss Monteiro. Miss Monteiro texted his sister that he threw me on the ground and pulled my hair and strangled me. My phone is at 4%, and if I die, it was Greg. Family members then tried to communicate.
I don't know if they're going to point this out here, but I'm going to point it out that the sister Faith is the one who brought him to the police department. I read that somewhere too.
Communicate with Miss Monteiro and get her to it was hair and strangled me. My phone is at 4%, and if I die, it was Greg. Family members then tried to communicate with Miss Monteiro and get her to a place of safety, and she didn't respond right away. Ultimately, there was a response from her device that indicated she was attempting to continue to stay at Mr. Groom's residence. There was a search that was conducted on August 14th of Mr. Groom's property at 107 County Street in Rehobeth, which is approximately a 25-acre property. That search involved members of the State Police CERT team, the Air Wing, divers, cadaver dogs, and nothing of significance was found during that search. However, based on the failure of Ms. Monteiro to contact any friends or family, the police continued their investigation. Ultimately, yesterday on August 19th, Mr. Groom reported to the Rehobeth police station for an interview. During that interview, he admitted that on August 6th, he had gotten into an altercation with Ms. Monteiro where he pushed her, she fell backwards, and she hit her head. When she attempted to contact an individual, Mr. Groom admitted that he knocked her cell phone out of her hand, at which time he was going to be charged with the 3 offenses for assault and battery on domestic assault and battery on a pregnant person, and for intimidation of a witness. When investigators continued to press Mr. Groom on the whereabouts of Ms. Monteiro, they informed him that they had applied for and were granted a search warrant for an extensive search of 107 County Street. That included not only cadaver dogs, but excavators, chemists from the Massachusetts State Police Crime Lab, and other investigators. And they informed Mr. Groom that they were prepared to search the property and dig if necessary. Mr. Groom then paused. He was given an opportunity to tell the police where Ms. Monteiro's body was located, either by being taken to his property and pointing it out, or drawing a map, or telling the officers where her body was located, as they believed Ms. Monteiro was dead. Mr. Groom.
If you're not looking at your screen, just come look at your screen and get a look at this guy. Zero motion, which is, typical in psychopaths. Zero motion. I don't think his face has moved once.
Ultimately drew a rudimentary map indicating that he got into an argument behind a shed on the property where he was known to stay and where Ms. Monteiro stayed. That during that altercation, Mr. Groom admitted that he stabbed Ms. Monteiro twice in the neck and once in the chest. The stab wound to the chest actually broke the blade of the knife off. He used a kitchen knife to commit the stabbing, and based on that stabbing, Ms. Monteiro was deceased. Mr. Groom indicated to the police that he then spent several hours digging a hole in the woods, approximately 20 yards from where he killed Ms. Monteiro. And through the night after he dug, when the sun came up, he then pushed her body into the hole and covered it up. He drew on the map the approximate location of Ms. Monteiro's remains. Officers who were conducting the search warrant then went to the shed. They noticed there was a large pile of brush right next to the shed. That was what Mr. Groom used to cover up the site of the murder, to cover up blood that was ultimately recovered, and physical evidence was recovered from the scene where the police alleged the stabbing occurred. About 20 yards away in the woods, there was another large pile of brush with feet upon feet of trees, cut down trees that were piled up. Underneath that pile, the police located a rectangular hole that appeared that had been recently disturbed dirt. When the police ultimately called in medical examiners to uncover that hole, a body consistent with Kylee Monteiro was discovered approximately 5 feet underground. Ms. Monteiro's remains were recovered last evening, and her body is at the office of the chief medical examiner undergoing identification process and undergoing an autopsy. Based on this.
Well, let's hope it's not the same medical examiner who did the autopsy on Sandra Birchmore, or she might, rule it as suicide. We have a WD-40. That's so funny, Rubicon, that you just said that. We have a WD-40 emoji for members, and that is one of the reasons we have it, is because one of the trials we were watching had such a squeaky door that somebody said, can you make a WD-40 emoji? And yeah, this has a squeaky door too. About 20 feet from the shed, he dug a hole 5 feet deep. Yep.
Case the defendant's confession and the prior domestic, the Commonwealth asked this court to hold the defendant without bail.
So no argument, Your Honor.
Trying to be held without bail.
And any date that is convenient for counsel for probable cause hearing.
About 30 days out.
Sure, whatever date works for you.
How about September? September 9th?
That's fine. Probably fast.
Oh, can we do the 10th instead, Your Honor?
Whatever day works for you.
Thank you.
September 10th, probable cause, courtroom 3, defendant is held without bail.
Thank you, Your Honor. Thank you, Madam Clerk.
I'll see you downstairs.
That court officer had backup.
Now to a story
He had backup. There was another one there, another officer there to help him. Emily C. says, the courtroom sounds like sitting on AOL Instant Messenger in 1998. You're not old enough to even know about AOL Messenger, girl. I can remember having that in my office, though, and having it on my desk, and that was funny. That was a funny reference that you probably read about because you're too young to even know about that. I think you know Love of the Traveling Trooper, just so I've been here for 3 months. Congratulations. Happy 3-month anniversary to us. None of your business said, has anyone ever escaped from a court hearing? Just curious. And somebody put in the chat that somebody in Norfolk County had escaped. But you remember that defendant who jumped on the judge in like Nevada during a court hearing? He launched into the air like Superman and he landed on top of the judge. It was wild. So yeah, it happens. It happens. And then there was a trial about what he did during that arraignment or whatever it was. I forget that guy. Remember that guy? He was like the ninja guy. Yeah, it happens. Beagle Mom is here. Thank you for your super sticker. Lizzie Bone says, I would love to move to Colorado, but I need information about snakes and scorpions. Currently in Norfolk County, maybe snakes and scorpions are better. You're the best. Thanks you for your coverage. I have never, all the years I lived in Colorado, I never saw a scorpion or a snake. So I don't know. A lot of Colorado people in the chat, but I see snakes here in New York. I don't see snakes. I never saw one in Colorado, so I wouldn't worry about that. That's more like desert. That's like if you're moving to like Joshua Tree, maybe or something in Arizona, but I've never seen a scorpion in Colorado, like ever. All right, so we're going to follow up on that. September 10th, there will be a probable cause hearing for Gregory Groom. He's confessed, but you know what has happened is that many defendants say they confess, and then it's a false confession, and then it's an issue in the end. AOL just went out of business, yeah? Angela says, I used to use AOL Messenger. I was like 10, and I'd be horrified if my kid did what I did online back then, ASL. I remember when I was around that age, I don't think I was 10. I was probably 13, sitting in my dad's car, playing on the CB radio, talking to truckers. Like, did anybody remember that? Breaker 19, Breaker 19. My handle was Wild Child. Go figure. And you could just go, like, this is, a long time ago, before the internet, before the cell phones, you could just go on the CB radio and just talk to people. That was crazy. Breaker 19, Breaker 19, Wild Child. What's your location, or what's your give me some more. 10-4, 10-4. What were the other things we used to say on the CB radio? And my father was not a trucker. Everyone just had one in their car. He had like a little tiny Mercedes convertible, like a vintage one, and he had a CB radio. It was crazy. Breaker 19, Breaker 19. What's your 40? That's it. What's your 40, Kokomo? What's your 20? What's your 20? What's your 40? I don't remember. I don't remember the lingo now, but I do remember party lines also. What's your 20? Oh my God. So everyone had them, right? You're going to think I'm crazy, but everyone had them. What's your 1040? What's your 20? I don't know, but it was crazy. Grace said, oh my God, my father-in-law's handle was Creeping Scar. Wow. Breaker 19, Breaker 19. Yeah, we had to entertain ourselves some way. And I was telling my kids the other day, they all know, I want my kids to turn off their location because if you're on Snap Maps or whatever, Snapchat, like everybody knows where you are at all times. And so I forced them to turn that off because like, they'd be like, Mom, everyone's in Aruba right now for spring break. Why can't we go to Aruba? I don't know. I was never an Aruba fan. I have other places that I'd rather go than Aruba, number one. Number two, why does everybody need to know where you are at all times? Tell your kids to turn that shit off. And I said, listen, we didn't have cell phones. We had a phone in the house before call waiting that had a big long cord on it. And you couldn't call your friends unless someone wasn't on the phone. And if someone was on the phone, people would call and they would get a busy signal. And back in the day, we just had to say, if we were going to the Dead Show at Nassau Coliseum, I'll meet you at the flagpole at 6 o'clock. And somehow, some way, we always met our friends. We always found each other at the flagpole at 6 o'clock. That's the way we did it. We didn't track each other's location. We met at the flagpole. And if you're from Long Island and you ever used to go to shows in Nassau Coliseum, you know the flagpole was the meeting place. And we would always find each other somehow. Somehow we did. We survived. I don't like it. I don't like being constantly available. People think you need to be getting back to them. It's just like there's no incognito anymore. It's too much. It's too much. I think it's stressful on our kids. And it's stressful on us. And now you're expected to work 24/7. What do you mean? I emailed you. Okay, but it was 9 o'clock on a Saturday. Yeah, but you're supposed to be on the clock all the time. You're supposed to respond. It's too much. It's too much. It's too much. Rant over. Meet at the flagpole. Or yeah, meet at the mall. I'll meet you at the mall, Roosevelt Field. We'll go to Roosevelt Field. I'll meet you in front of World Imports at 2 o'clock. And somehow, some way, we found each other, right? Or the collect call. Oh, this was a good one. And I saw like a rant about it. I forget where, Instagram maybe, the collect call. And we used to figure out the way to scam the collect call because we would just say, you know, if you didn't have a quarter or a dime or whatever it was to use the payphone, you could make a collect call. And you could say, you could call your parents, collect. And when it said, they would say, would you like to accept a collect call from, and then you would just yell in the phone, 3 o'clock, Roosevelt Field. Your parents would know when to pick you up without having to pay for the collect call. Does anybody remember doing that? I think it was like the 80s or something. I don't know. It's been a long time. But we found a way to get around the collect call because collect calls were expensive. Phone bills used to be really expensive. There was no such thing as unlimited calling. I had a boyfriend who went to college, like not even far away, like upstate New York. And the long distance phone bills were out of control. Hundreds of dollars a month. I used to get in so much trouble. Hundreds of dollars a month in long distance charges. It's crazy. collect call from Bob had a baby. It's a boy. Very good, Kelly. Very, 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 very good. Oh, so funny. Call after 9 p.m. It was cheaper. Yeah. Oh my God. I had a pager. I had a pager too. I had a Palm Pilot. I still have my Palm Pilot. It's going to make a great prop one day. But yeah. Do you remember if you had a pager, you could say hello in numbers? It was like 43770. And then the person would turn it upside down and it would say hello. Boy, we were so creative. 143 meant I love you, remember? Oh my God. The pagers. And then you'd have to call back. It was the whole thing. I had a bag phone in my car too. Those were the days. Those were the days. Okay. Back to Kylee Monteiro, because again, this is always about the victim, always. And this was posted on Facebook. I hate Facebook, but I go to it for certain things. This is one of them. 20 hours ago by Faith, who is Kylie's sister. And she posts 20 hours ago. This is the link to Kylie's obituary and funeral arrangements. Everything is open to the public. Anyone that wants to come and pay their respects is more than welcome. And there's a picture of Kylie. And then below that, and I'll put that up in a second, but it says, this is Kitty Monteiro. I'd just like to give a shout out once again to Faith, the Rehobeth Police, and Mass State Police for their diligence, dedication, and nonstop hard work in resolving this case. I'd also like to thank everyone involved in this, including Mike, John, and Elizabeth specifically, for being the first people to take this as seriously as we did. The media, as well as every individual person who kept up with our story, from sharing to tipping us off to full cooperation with police and family members. From the bottom of my heart, thank you. I know this is not the ending we all wanted, but this is closure for us, and this gives Kylie the opportunity to rest in peace with her mom and her baby. Without you guys, she might not have found peace for years, and that's something that very few people get in cases like these. I think it's a good time to remind everyone to check in regularly with people, tell them you love them every chance you get, take photos every single day, and don't ever forget that people love you. So many people. You will always be remembered, Kylie and baby Eleanor. Oh. The baby was going to be named Ellen. I'm going to put up the, so I guess Kylie's mom died before her. So sad. before she did. And here are the arrangements and the obituary. Reads as follows: obituary for Kylee Marie Monteiro. Attleboro. It is with profound sadness that we announce the passing of Kylee Marie Monteiro, 18, a beloved daughter, sister, granddaughter, niece, cousin, and friend, who left us far too soon on Tuesday, August 19th, 2025. Well, that wasn't the date of her death. The date of her death was like the 6th. Born in Providence, she was the daughter of the late Carrie Fisk and Michael Monteiro. Kylee resided in Burrillville before moving to Attleboro about 6 days ago. Her mom and dad both passed. Kylee was a bright and spirited young woman who graduated from Attleboro High School in 2025. With a passion for welding, she proudly earned her welding certificate and was eagerly looking forward to a promising career in the field. Her vibrant personality shone through her love for posting on the internet and interacting with her friends. Above all, Kylee adored her sisters and niece, cherishing every moment spent with them. Kylee is survived by her beloved siblings, Catherine, Faith, Michael, and Haley. She was the treasured granddaughter of Louise and Wayne Allard, Michael Sr., and Pat Monteiro, Gail Fisk, and Eva Fisk. She also leaves several aunts and uncles, including her devoted aunt, Kelly Murphy of Attleboro, Mass., who, along with her husband, Joel Murphy, lovingly raised her after the passing of her mother. Oh, wow. So she was raised by her grandparents. She also leaves many cousins who will forever hold her memory in their hearts. She was the granddaughter of the late John Fisk and the niece of the late Kenneth Fisk. Visitation will be held on Thursday, September 4th. That is this coming Thursday from 4 p.m. until 7 p.m. and continue on Friday, September 5th at 11 a.m., followed by services at noon at William Tripp Funeral Home, 1008 Newport Avenue, Pawtucket. Interment will follow at Newell Burying Ground, South Attleboro. In lieu of flowers, memorial gifts to New Hope, 247 Maple Street, Attleboro would be appreciated. Kylie's family would like to extend their heartfelt gratitude to all who have offered their support and condolences during this difficult time. For online condolences or to share memories, please visit trippfuneralhome.com. Kylie's light will continue to shine in the hearts of those who knew and loved her. She will be deeply missed and lovingly remembered by all. To send flowers or a memorial gift to the family of Kylee, please visit our sympathy page. So sad. Plant Lady says, so sad, what a monster. Prayers for her family. Yeah, prayers for her family. So sad. Well, in other news, let's leave it on a light note, shall we? But before we do that, we have one more sad story, and that is there's been some information in the story of Enrique Delgado Garcia, who was killed, who died during a boxing training exercise. While he was at the police academy for the Massachusetts State Police in Braintree, I believe. Was it Braintree, North Braintree, South Braintree, East Braintree? I don't recall, but maybe the I team is going to tell us, because here's a story that came out, I think, just yesterday.
Now to a story the I-Team broke in September. We now know the cause of death for a state police recruit who was seriously injured and ultimately died after a boxing training exercise.
Today, the medical examiner released the autopsy report to Enrique Delgado Garcia's family. Here's our chief investigator, Cheryl Fiadaca, with the newest details.
Massachusetts State Trooper Enrique Delgado Garcia died from complications from blunt force injuries, according to the medical examiner's autopsy report given to the family.
He had blunt force injuries to the head and neck. He had contusions surrounding the right eye, contusions overlaying the left eye. He had internal injuries.
So what is all that?
I just want to point out, so did John O'Keefe. So did John O'Keefe. Contusions here to the right side of the head, the left side of the head, the frontal lobe of the brain. So he was beat to death. Enrique Delgado Garcia, blunt force injuries caused in a boxing ring, either fight night, the big fight. With how many witnesses? I'm going to take this back. Yes. They did try and blame it on sickle cell trait. I remember covering this when the story originally broke, all the way back in September. This is what in limine says. This is why they were not talking, because it was the same. Let's take it back. Blunt force injuries to the head, just like John O'Keefe. Listen.
Twisted Tales.
Massachusetts State Trooper Enrique Delgado Garcia died from complications from blunt force injuries, according to the medical examiner's autopsy report given to the family.
He had blunt force injuries to the head and neck. He had contusions surrounding the right eye, contusions overlaying the left eye. He had internal injuries.
So what does all that mean to you?
He took a severe beating and had brain injuries as a result of repeated blows to his face and head.
Last fall, Delgado,
just like John O'Keefe. Daily Mail did use my YouTube? Really? Without my consent? Oh, that's going to be interesting. I'll pull that up in a second. They didn't want this information coming out during Karen Reed's trial because it may have just set off a light bulb in some people's heads. Remember, his family had originally said, I think he had all his teeth were broken. He had a fractured neck. This story needs to go viral, says Tina. I know that's what you're saying, Ash and Sugar, but I'm going to take a look at it in a second. Thank you. I said at the top of the show, I don't know if you were here, they asked me to use it. I didn't respond because it's Howie Carr's content. They need to ask Howie Carr. And I reached out to Howie to see if he would give permission or if they should contact him directly. And I haven't heard from them, but they used it anyway. That's interesting.
Garcia was 5 months into his training at the Massachusetts State Police Academy and was participating in a boxing exercise when he was seriously injured.
And the other thing that's particularly troubling, Cheryl, is don't forget, during the course of all of these boxing matches that day, and this one in particular, there was a referee in the ring. So when Enrique was knocked down the first time, why was it that the referee would allow the boxing match to continue and allow him to receive the pummeling that he did?
The 25-year-old's death sparked an independent investigation and led to reforms at the State Police Academy, including the suspension of the boxing program.
I think that the state police were reckless in instituting this program after some prior problems with it. I think they were reckless in the manner in which they aligned the two young men up to fight. I think they were reckless in the manner in which they supervised the event. And I think they were reckless in the manner in which this fight unfolded.
The family is still waiting for the report from the...
Well, he's talking like a civil attorney who's going to file a wrongful death lawsuit against the Massachusetts State Police. They were reckless in the way that they did it, and their supervision and their control, and that's what it sounds like that attorney has been hired to do, and God bless him. Absolutely unacceptable. Odin the Good Kitty says it was on Mass Live. They said equivalent to a 100-mile-an-hour crash. Rhiannon said, I think a code red was ordered. Carla said he was deliberately beaten to death. That'll be harder to prove, but we know there's video of it. The entire thing was videotaped. What we don't know is whether people were betting on the results, because when I first covered this, or one of the first times I covered it, I fell into a rabbit hole, call me Alice, and I found a lot of other stories nationwide of the same thing happening during police academy training exercises. And in some states, it's called the big fight. And in some places, it's called fight night. And there's betting going on. And there are like professional boxers coming in to, you know, to really put these guys, take these guys to the mat, excuse the pun. And, you know, officers who are not trainees, who are much bigger and much stronger. It's a thing. It's sick. I agree, Sue. It's sick. That's good. Fight night. It's like fight night, fight room, fight club. But nobody talks about, first rule of Fight Club is nobody talks about Fight Club, right?
Independent investigation and says it will hire its own expert to review the autopsy report. Cheryl Fiandaca, WBZ News.
Just moments ago, state police released this statement. Quote, the state police has fully cooperated with the ongoing review of this tragedy, and we await the findings of that independent inquiry.
Well, they've fully cooperated. Well, I guess good on them. Oh, I guess I bookmarked another piece. So let's listen to this piece as well. It's only 3 minutes. Can't give Enrique Delgado Garcia enough airtime. God rest his soul. His family was forced to make the decision to cut off life support after they were told that he was brain dead. And to my knowledge, none of the other recruits have come forward. A lot of them did quit after this incident. And his organs were donated. I remember that too. So sad. All right, let's listen to NBC 10 Boston's piece on it from yesterday.
The precipitating event here was blunt trauma to his head, repeated blows to his head.
Breaking at 6, new details about the Massachusetts State Police recruit who died from injuries he suffered during a training exercise at the academy. Thanks for joining us tonight here on the News at 6. I'm Priscilla Castle.
And I'm Colton Bradford. An attorney representing the family of Enrique Delgado Garcia says an autopsy report is finally providing some answers. He spoke with NBC 10 investigator Ryan Kath about what that report concluded. He's joining us live from the newsroom. Ryan?
Colton, the attorney, tells me that the autopsy report validates the serious injuries family members described when they saw Delgado Garcia in the hospital. It lists his cause of death as bleeding in the brain caused by blunt force injuries to the head. But tonight, questions still linger about how a supervised boxing exercise ended so tragically.
It went from a training exercise, in my estimation, from a training exercise to a fight.
Attorney Michael Wilcox says Enrique Delgado Garcia was wearing protective headgear during a boxing exercise at the academy last year. So it would have taken extreme and repeated force to cause the fatal bleeding to his brain. The recruit was pinned to troopers shortly before he passed away at the age of 25.
I think there was a criminal lack of supervision. I believe that people that were supposed to be monitoring Enrique failed to do so. And I think it is the questions remain unanswered as to why that was.
Delgado Garcia worked as a victim advocate in the Worcester District Attorney's Office, so DA Joe Early recused himself to avoid a conflict. That's why Massachusetts Attorney...
Remember when DA Joe Early paraded the family to the press conference and had them up there and would not let them speak? That was so cringe, and it was so hard to watch. And he recused himself. Because Enrique, prior to joining the police academy or enrolling at the police academy, had been a victim witness advocate in the county. He wanted to do such good things.
General appointed an independent investigator, veteran trial attorney David Meyer, to get answers. And there have been few updates since then. In a statement, a state police spokesperson said, as we approach the first anniversary and continue our review of training practices, the department shares the Delgado Garcia family's desire for a thorough accounting of the facts and circumstances of his tragic death. The state police have fully cooperated with the ongoing review of this tragedy, and we await the findings of that independent inquiry. In the wake of Delgado Garcia's death, leaders at the agency suspended the boxing exercises at the academy and ordered a review of the defensive tactics program. Wilcox told us a heart condition called myocarditis was also listed in the autopsy report as a possible contributing factor. But he says it's clear that if they had pulled the plug on the boxing...
they didn't put in the sickle cell trait, which they did in all of the other cases nationwide that I looked at. They always like to put sickle cell trait as a cause of death in these types of cases for some reason, in these fight night cases. But it seems like myocarditis, a heart condition that he didn't even know that he had. Come on, man. Are you buying it? Hold on.
Told us a heart condition called myocarditis was also listed in the autopsy report as a possible contributing factor. But he says it's clear that if they had pulled the plug on the boxing exercise sooner, it would have avoided a tragedy.
An otherwise extremely healthy young.
Pulling the plug, not the best choice of words there. Not the best choice of words, because his family did have to pull the plug on him because he was brain dead. So pulling the plug on the boxing exercises, who's editing your stories, Boston 10? That was horrible.
Contributing factor, but he says it's clear that if they had pulled the plug on the boxing exercise sooner, it would have avoided a tragedy.
An otherwise extremely healthy young man in the middle of police training who was doing quite well, no issues whatsoever until he's exposed to repeated blows to his head during a boxing match that was completely unnecessary.
Wilcox told me the family has been getting regular updates from Meyer and his team, and he believes the independent investigation is nearing an end, but it won't be complete by the one-year anniversary of Delgado Garcia's death next month. When it's finished, it will likely be up to the Attorney General on whether or not to pursue any criminal action. Ryan Kath, NBC 10 investigator.
Look, I love it when it ends and then it suggests my video in there. Interesting. Hang tight for a sec, if you don't mind. Another tragic story out of New Hampshire, where a woman, we talked about this the other night, a woman in New Hampshire annihilated her family. She had been suffering from depression and had posted a couple of TikToks about her depression, and her husband was suffering from a fatal form of brain cancer. She, Madbury, New Hampshire, I believe, took the life of her husband and two of her young children, but not the 3-year-old toddler who was found safe upstairs. And apparently she is the killer. Then she killed herself. I originally, when I heard about this story, I thought it was the father who did it, but I knew there was going to be some more to the story. And the more to the story is the employer has come out of the woman and said that she had been caught embezzling over $600,000 from his company. Was that the catalyst for this? I don't know, but let's listen to WCVB, Channel 5. Tell us about it, because this also broke yesterday.
Well, Maria, that woman's boss tells me that he was trying to get answers this summer about all of that missing money, and then just last week, the tragic crime that shocked their community.
I felt like I had no other option but to go to law enforcement.
1 week before police found Emily Long, her husband, and two of their children dead in their Madbury, New Hampshire home, her boss filed this police report detailing theft from his company.
We noticed that there was a lot of handwritten checks in her name personally that were being deposited into her bank account.
Emily was the director of operations for the Wingett's restaurant chain. And earlier this summer, owner Derek Fisher says he started noticing significant accounting inconsistencies.
Wingett's. Anybody ever been there? Anybody ever been to Wingett's? Tell me about Wingett's. How does it take you so long to discover that $600,000 is missing? This is unreal. I knew there was more to this story.
Came up with as it started in January 2023. And over a period of that time up until July this year, there was over $660,000 that were taken.
Fisher says he tried to get answers for weeks before turning to police, and he gave it time because he knew Emily's husband was battling a brain cancer diagnosis.
I mean, giving her circumstances with her husband, I was trying to be considerate and patient.
On August 18th, Fisher woke up to the unthinkable. Emily, her husband, and two of her young children were found shot dead in their home, and Emily was suspected of pulling the trigger.
I was completely devastated and heartbroken. I cared deeply for her and her family. I was around all of her children as they grew up.
Emily's third child, a toddler, was not hurt, and now her boss can only focus on that boy and not the financial loss his company has suffered.
Anything that's left should go to that child. He deserves all of it. It's not fair to him. He didn't make this happen. He didn't deserve this.
So it sounds like somebody had said it was the 3-year-old daughter, but it sounds like it was a son who is surviving. I don't know why she spared the 3-year-old, but it's horrific. It's not because he had cancer, Misty. Right. That's what I was thinking too. Because she had posted a bunch of stuff on TikTok, like, oh, I'm going to miss him so much, and on and on and on. Oh, was she paying for medical care? Katie wants to know. I don't know. I'm sure there's going to be even more to the story, but they're all gone. There's nobody to prosecute, but we'll see what else comes out.
Investigators emphasize that there is rarely just one motivating factor in tragedies like this, and resources like the 988 Lifeline are available around the clock. Live in the newsroom, John Atwater, WCVB News Center 5.
In his prison letters.
Oh, yeah. Chris Watts says that God has forgiven him. Let me know if you want to hear about that, because that's wild too. I had that pulled up for you. Patty Minko says she started taking the money well before he was diagnosed with cancer. Is that, oh yeah? And that's what Emily says also. I think she started embezzling before his diagnosis. You rarely see women family annihilators though, right? It's rare. EKG, thanks for your 20. I wasn't allowed on the phone past 9 on school nights. I called the weatherman on redial until call waiting dinged. House phones didn't ring. And cord stretched to my closet with older siblings' phone time, constant negotiation. Do you remember you could call and find out what time it was? You could call the weather. Yeah, I remember that. Thank you for your 20. Bringing back the old memories. But you could also call to find out what time it was. And back in the day, they had a Grateful Dead. I know everything always comes back to the Grateful Dead for me, but they had a Grateful Dead hotline. So when the tour was announced, you had to call the hotline number to find out all the tour dates because, no internet and the news didn't report on that. And you had to mail in for tickets and people would decorate their envelopes. That was so fun. The Grateful Dead hotline. I still remember that too. And you could call and find out what time it was. Crazy. Thank you for your 20. Appreciate you so. Ms. Holmes has been here for 9 months and says, has the cadet Enrique was fighting been named? Nope. Nope, not to my knowledge. That has not been public at all. New Hampshire woman, thank you for your super chat. Possible she didn't want her children to live without both parents and figured the youngest wouldn't remember them anyway. But now it's escaping me how old the other two were. 4 and 6, and the youngest was 3. I don't recall. Anybody knows for sure, let me know. But that is possible. I don't think we can get inside her head unless she left a note. And I'm not sure that that's been made public either. But at the tone, the time will be 1:56 p.m. That's right. That's right. Kokomo, Indiana knows. Kokomo, Indiana. At the tone, the time will be 1:56 p.m. Heather even remembers the phone number, 853-1212, to call the time in California. Yeah, I think all 3 were 6 and under, right? Right, Kelly? Emily says, at the tone, the time will be 1:55 and 50 seconds. Beep. Temperature, 75 degrees Fahrenheit. I guess it depends on where you were calling from, right? Oh, yeah, the movie theater line. Oh, my God, that's so funny, Stephanie. And then, of course, just like the Grateful Dead, Seinfeld references are always welcome here, too. Do you remember when Kramer pretended to be the movie phone guy for like a whole episode? You used to have to call the movie theater line to find out what movies are playing and what time. Movie phone. And Kramer answered or pretended to be the movie phone line for an entire episode. Do you want to hear what Ashley Banfield has to say about Chris Watts thinking that God has forgiven him in prison? That guy, I mean, in my opinion, death penalty was made for guys like Chris Watts. Are you guys familiar with that case? 8 and 6. Thank you, DK94. 8 and 6. Okay, so 8 and 6, and then the baby was 3. Kramer is the GOAT page. episode was hilarious. Hilarious. Watts is the worst. His daughters were so cute. Yeah, Derek, I agree. Another monster. Well, he thinks God has forgiven him. I don't know if we want to watch this or even give this guy's face the time of day. I'll leave it up to you. Oh, he's got his fan club too. He's got his fan club. There's a lot of YouTubers out there who horrific. I'm not even going to repeat the things that they've said, but but don't repeat them in the chat. No. Gross. All right, let's leave it on a funny note anyway. White privilege at its finest. Wait, let me just see if there wasn't anything else here that I want to show you. We got Enrique, we got Gregory Groom's arraignment, we got the embezzlement. Okay. Let's talk about Devon Flanagan. Forget about Chris Watts. Some of you may not know about the story. Some of you may know about this story, but I got to check the Daily Mail too. Thanks for reminding me. Devon Flanagan is an AG. She's an AG in Rhode Island. She's an AG. She's an AG. She's an AG. We know she's an AG because she told the police that in the body cam footage at least, I don't know, 16 or so times. I'm looking at the Daily Mail right now. Hang on a second. Let us see. She's an AG. Tiff, she's an AG. Tiff, she's an AG. Oh, I also, on the thumbnail, I have Brian Walshe. So let me do Brian Walshe first before we talk about the AG. Alan Jackson, why is this just not coming up on the Daily Mail? Did they take it down? Hold on. Oh, Kyle. Thank you, Kyle. Oh, Kyle Sharkey. You're the greatest. She's the AG. She's an AG. She's an AG. All right. I got Kylie's bail conditions. I mean, Kelsey, Kylie, everybody with a K. Did anybody send me the link to the Daily Mail article? Because when I go on their page and I try and even just look up like Alan Jackson, it's not giving it to me. Hold on. Do, 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 do. Everything from Michael Jackson comes up. Wow, your search bar really sucks, Daily Mail. Search Karen Reed. Well, 24,000 pages come up. Oh, let's go to most recent. Okay. Oh, yeah, they do. They link me. Ah, and they put my Venmo QR code up too. You think anybody will Venmo me? All right, let's take a look at this. Thank you guys for checking for me, for looking out for me always. You look out for me. Here's the Daily Mail. This was published 29th of August, 2025, which was yesterday at 22:21 Eastern Daylight Time. Let's see what time they emailed me. Let me just pull out my email and see what time they emailed me. Oh, Cusco, you did email it to me. Thank you. I just found it when I was searching. Hold on. 8:10 p.m. At 8:10 p.m., they emailed me on a Friday night, Eastern Time, which would be 2 hours before they actually published it. Good evening, Melanie. My name is Nick, and I'm reaching out from the Daily Mail in New York. How are you? We're hoping to get your permission to run a short clip from your Alan Jackson interview video on the following link in our web player on socials to accompany an article. Would this be possible? And then they link it. We would credit the video to you and link back. Please let us know if this would be possible or if you have any questions. Our T's and C's are below. How about T's and A's? T's and C's, terms and conditions. Many thanks, Melanie. Have a great evening. Nick Hopkins, video producer, Daily Mail, London, New York, with his direct phone number in New York City. And I did not submit my content. I did not give you permission, but it doesn't matter because they took it anyway, because that's what they do. Here's the article. Karen Reed describes slow return to normal life after a 4-year murder trial ordeal. Oops. Hold on. I just lost it. It went off my screen. Hold on. I got too many tabs open. Give me a sec. Remind me later. Go away. Go away. Go away. Where's desktop 2? Oh, where did this go? Come back to me. There it is. Okay. With 400 pop-ups. Karen Reed describes slow return to normal life after a 4-year murder trial ordeal as she reveals next move. Gotta love the pop-ups on the Daily Mail. Let me get into reader mode here. Karen Reed has spoken out for the first time since being acquitted for the death of her boyfriend, revealing she intends to write a book documenting her horrific ordeal. Reed was dramatically acquitted of murdering John O'Keefe, a Boston police officer, in June of this year in a retrial that both gripped and divided America. On Thursday, Reed appeared on the Howie Carr show and spoke publicly, the first time since her acquittal, revealing what life had been like since she was granted her freedom again. Post-trial, Reed says, it's not quite what I expected. It's a little like a dimmer where the lights are coming on a little brighter each week, she continued. There's moments I have every day, these little epiphanies of, wow, this is the first time I've done fill in the blank in the last 4 years that I was living with this nightmare. Reed, who's now living with her parents, added, I feel lucky. I've lost a lot, but I still have what's most important. My parents are in their late 70s, and I'm grateful they're still here. She revealed plans to tell her story in a book, adding, I don't always know what's next, but I do want to write a book. There's so much more people need to hear. I felt she was very fragile during that interview. It has not been easy to get her life back. That, she's been dealing with this or had been dealing with it for 3.5 years. Her life has been turned upside down, and it's not so easy to just go back to normal life, And thankfully, she's been able to take some time off and spend some time with her parents, and so sad. Her story is set to be made into an upcoming Amazon Prime series with Hunger Games actress Elizabeth Banks rumored to take on the role of Reed. It's not authorized by me in any way. I've never spoken to her. This is my story to tell, Reed said. I don't think Reed said that. I think Alan said that. This is her story to tell, but it's the Daily Mail. Reed was dramatically acquitted of murdering John O'Keefe in June of this year in a retrial that both gripped and divided America. Attorney Alan Jackson revealed on Thursday afternoon that he and his client are exploring filing a civil suit over her murder prosecution that saw Reed acquitted in June. Reed and her attorney, Alan Jackson, appeared on the podcast where Jackson discussed their potential civil suit being filed over her prosecution on this segment. It was his radio show. Is it a podcast? I don't know. Jackson said, I'll say this. I'm back here for a reason. It's not just a pleasure tour. We've met with the legal team back here dealing with the civil issue. There's obviously a lot to unpack where that's concerned. So had and will continue to have significant meetings about that, what Karen's next options, what her options are in general, but what her next moves might be. And we're considering all options. He declined to go into specifics about what the civil case could entail, but added nothing's off the table and no one's off the table. Reed's attorney noted that in order to fund her legal battle, she had given up her home, her car, lost her career, and 4 years of her freedom. Reed's acquittal is far from the end of the grueling legal process, and she is now facing another round in court. And here are some photos. On Thursday, Reed's attorney Alan Jackson said on the Howie Carr show that the O'Keefe family is going to have a very, very, very significant uphill battle. Very obviously, the jury has spoken. The suit alleges that Reed and O'Keefe argued into the midnight hour of January 29th, 2022, and that O'Keefe left Reed's car, and in a state of intoxication, Reed drove her SUV into O'Keefe, who suffered serious injury and died. Reed and her legal team are gearing up for a civil trial, a $50,000 wrongful death lawsuit filed by O'Keefe's family against her. Well, no, that's wrong. You have to say it's worth $50,000 or more to get into superior court, but they're not just looking for $50,000. So there's that. It wasn't like there wasn't an enormous amount of scrutiny that was put through all the evidence against her. 2 times, not once, the jury determined there was no collision, he continued. Now, as they prepare their own civil suit, Reed's attorney said that he is back here for a reason. It's not just a pleasure tour. We're not finished with the court system, and the court system is going to allow me another opportunity and another platform, and allow Karen another platform to get the truth out, and we damn well intend to do it, he said. Reed's attorney noted that in order to fund her legal battle, she had given up her home, her car, lost her career, and 4 years of her freedom. This is weird. Right above Judge Cannoni's picture, it says, "Moment shaking judge ends Karen Reed murder trial hearing." Shaking judge? We've met with the legal team back here dealing with the civil issue. There's obviously a lot to unpack where that's concerned. So had and will continue to have significant meetings about that, what Karen's next options, what her options are in general, but what her next moves might be, and we're considering all options. Jackson said that he wasn't sure any amount of money could reasonably compensate her. I said that too. You can't write a check big enough. I can guarantee you that civil case will be righteously defended, and that means getting every single scrap of information that we're entitled to and that we did not get during the criminal case, he added. She was jailed twice too many times, and both times jurors determined there was no collision, Jackson said. Reed directed a chilling accusation at the Massachusetts State Police, who investigated her, and Norfolk County District Attorney Michael Morrissey, who prosecuted her. You lost big time, and you know what you did, what you've done, Reed said. Well, back to the non-reader view of the article, you will see picture of Karen Reed. We went over this all the other day. And my video right there. Marianne Janelle, you're famous because they took, well, does it play my video though? No, it doesn't. It's just a screenshot of my video. With my Venmo QR code. Thank you, Daily Mail. So I don't think they linked it. Let me see. Oops. It's just a gallery. Oh, and they did credit me for the screenshot at Attorney Melanie Little on YouTube. So I wonder if anybody came over here from that article in the Daily Mail today. But they didn't link to the video. All right, first time ever that I made the Daily Mail, and it's not for something that I did that was scandalous. So there's that. So I got that going for me. Like the time I made page 6 in the New York Post. And the reason I made page 6 was because I was representing SNL cast member Daryl Hammond in a car accident case that happened in Sag Harbor. So 2 times I made the tabloids, and for things that I did not do, but for things that I did as an attorney. So I got that going for me. Brian Walshe. Okay, let's get to Brian Walshe. Brian Walshe has filed an appeal, an interlocutory appeal on the suppression issue. And remember, I was not happy with Judge Frenier's decisions on the motions to suppress. And so I said, and many of you had the question, can they appeal this before the trial? And I said, well, let's look it up. And we looked up the interlocutory appeal. Very slim reasons that you can do an interlocutory appeal. Interlocutory appeal is an appeal that is pending, an appeal that you can make before the final conclusion of the case. Some appeals have to wait until after a conviction. Some appeals can be made during the course of the case, and they will stay the case if the SJC decides to hear it. It will stay the trial in the Brian Walshe case, which is scheduled for October. So I was happy to see this filing by Larry Tipton, who we love. We love Larry Tipton. He represented Petty McGee. He is maybe the best public defender in Massachusetts, in my opinion, because we've seen him in action and he's on fire. And I love how his motions look like they were typed on an actual antique typewriter. And so I disagreed with Judge Frenier's decisions. And I am very excited to say, or to see, that they have filed an interlocutory appeal. I'm not going to read the whole entire thing to you because it's 24 pages, but let's get the gist of it for those of you who are not caught up on the papers. We'll catch up on the papers. A little bit. Docket number 147 in the Brian Walshe matter, docket number 147. For those of you who are not familiar with the Brian Walshe case, I have an entire playlist on the Brian Walshe case. And what is horrific about the Brian Walshe case is that Brian Walshe is accused with taking the life of his wife, Anna Walshe, back in, let's see, it was 1 year after John O'Keefe's murder. So it would be January 2023, right? New Year's Eve, New Year's Day, January 2023. This is a no-body murder case. A lot of the same law enforcement involved. It's a Norfolk County case that originally had been assigned to Judge Cannoni. It was then taken from Judge Cannoni and is now in front of Judge Frenier. Michael Proctor was the lead investigator in the investigation into the murder of Anna Walshe, or the disappearance of Anna Walshe, because he's a missing person. Yuri Buchanan is involved. John Fanning is involved. And unlike Judge Cannoni, Judge Frenier ordered an evidentiary hearing in the Brian Walshe case, which we watched as much as we could get our hands on. And we watched the testimony of Yuri Buchanan and John Fanning and some other of the players that were involved in the Karen Reed case. Yuri Buchanan had such a different demeanor on the stand in front of Judge Frenier than he did in front of Judge Cannoni. And they seized Brian Walshe's phone on consent. They took his phone. He agreed. They did a total extraction of his phone. And during the extraction of his phone, the Massachusetts State Police, including Garino, and I think it was Trooper Connor Keefe, found such things in the phone, such as Google searches, that would, in my opinion, absolutely convict him. YouTube doesn't like when I say what the Google searches were, but you can Google the Google searches and you can say what they were. Such things as, what is the best tool for dismemberment? How to dispose of a woman's body if you really need to. Things about smells and stenches of decomposing bodies, and what are the best chemicals used to cover them up. During that total extraction, they also found Brian Walshe's location data. And they used his location data to track his movements. And by tracking his movements, they found that he went to Lowe's, he went to Home Depot, he went to Home Goods or TJ Maxx or something such as like that. Don't kill me on the details right now, but they have videos of him leaving Home Depot with things like buckets, a mop, 6 different kinds of hydrogen peroxide. Then at another store, buying a Tyvek suit, a hacksaw, cleaning supplies. But the way that they got those videos is because they'd got his location data off of his phone. And the way that they got those Google searches is because they got the Google searches off of his phone. And the question was the scope of the consent that Brian Walshe gave for the Massachusetts State Police to search his phone. And that is what the evidentiary hearing was about. And there were very long motions and very long oppositions, and we went through most of those. And then we went over the decision by Judge Frenier, in which she decided that Tracy Minor, the attorney that Brian Walshe had at the time, because Brian Walshe was also facing felony charges for selling fake Andy Warhol paintings on eBay to an art collector who collected Andy Warhol paintings. And he was on house arrest with an ankle monitor. And we found out that the ankle monitor GPS did not track his location. It only tracked what time he left his house. Don't ask, I don't know. So what had happened was Michael Proctor, in his infinite wisdom, used the illegally searched, in my opinion, device and the things that he found on the device as probable cause for the search warrant to search the house and car. The question here is, what was the scope of the consent? And whether, even if they went outside the scope of the consent, these things would have been inevitably discovered. And in Judge Frenier's long decision, her long-ass decision, I thought she didn't think Tracy Minor, the attorney who did testify at the evidentiary hearing, that was not televised. We could not get her testimony. She didn't give her testimony any weight, but completely believed everything Yuri Buchanan had to say. Yeah, Scott, kindergarten cop, you can shut it down. I don't care whose feelings are hurt or aren't hurt. He says this is a drama-free zone. Yes, it is. And I give you permission to delete all those comments. I don't care. I don't care. I'm not involved in the drama. I don't care about it. And that's not what I'm here to do on YouTube. And I don't care. So you have my permission to delete all that nonsense if you want to. Just get it out of the chat. I don't have time for it. And Judge Renier found that they did not go outside the scope of the consent. But even if they did, she took the totality of the circumstances. Yuri Buchanan's testimony about what he thought the scope of the consent was. They didn't call Lynn Beland, the attorney, the head MF in charge next to the right hand of Michael Marcy. They didn't call her in to testify at the hearing. And so let's see what happens with this appeal. But Larry Tipton isn't having any of it. He has filed an appeal on this issue. And I'll read for you, for those of you who are not familiar with it, what the gist is of the appeal. And then you can let me know your thoughts. And I'm going to read to you again the scope of the email and the consent between Lynn Beland and Tracy Minor, Brian Walsh's attorney. And I discussed it at length why I thought the judge was wrong. And I'm glad that Larry Tipton filed this. And what will happen will remain to be seen. But here it is. It is the Memorandum of Law and Fact in support of defendant's application to a single justice pursuant to Massachusetts Criminal Rule 15, which means that they can take this up and have one judge decide it rather than the 3-judge panel at the SJC, is what I think that means in Massachusetts. I didn't have hella time to research this, but that is what they're asking for here. And here's what they say. Give me a second to get a drink. On January 6th of 2023, a consent agreement was reached between the defendant's prior counsel and the Norfolk DA to turn over digital devices and specifically limited to a search for communications only, excluding attorney-client communications encompassing December 25th, 2022 through January 6th of 2023, period. The trial court found that the consent agreement permitted the examination of any and all data on the digital devices and concluded there was no violation of the consent agreement, period. In reaching its decision, the trial court made critical findings of fact and conclusions of law that are clearly erroneous on the issue of whether the police exceeded the scope of the consent to search the digital devices. But note one, the defendant does not argue that the trial court's findings and conclusions that there was no coercion in obtaining the consent is clearly erroneous and limits his arguments to the trial court's findings and conclusions regarding the scope of the consent issue and inevitable discovery. So when you file an appeal, you got to pick your issues, right? And so he's narrowing the issues for the appellate court for purposes of this appeal to make it a little bit easier for them. Instead of throwing spaghetti at the wall, he is going to narrow it down. The trial court misapplied the totality of the circumstances standard applicable to the consent issue, citing Commonwealth v. Ortiz. The trial court concluded that the defendant's prior counsel was not credible, a finding not supported by the facts and clearly erroneous and against the weight of the evidence. The trial court went outside the plain language of emails exchanged between the defendant's prior counsel, Tracy Minor, and the first assistant to the Norfolk DA's office, Lynn Beland, to interpret the consent agreement. And that was one of my arguments too. That when you're interpreting contracts or agreements, this is Contracts 101, they teach it to you in law school. The court is supposed to look at what is inside the four corners of the agreement. The four corners of the agreement. They're not supposed to look outside to, certain other oral representations that may or may not have been made. And that is exactly what Judge Frenier did here. The four corners of the agreement is what is supposed to govern. And so that is just one of the reasons I thought Frenier's decision was wrong. But let's see what else Larry Tipton has to say. Point two, the trial court's conclusion that even if the consent agreement was violated, the information seized from the illegal search of the digital devices would have been inevitably discovered. This conclusion of law, in fact, is clearly erroneous and misapplies the relevant facts and existing law. Brief summary of relevant facts. There's some confusion. Okay, Laura, this is a great question. Laura says, when is the rest of the evidentiary hearing going to resume? The evidentiary hearing that was held on this issue is completely different than the one that you're thinking of, I think, which is when Lally testified. This evidentiary hearing was only held on the Walshe case, and it had to do with the phone and the child's iPad and whether Buchanan and the MSP went outside the scope of the consent to download all of the information on and look at all of the information on Brian Walsh's phone. That evidentiary hearing is over. That was, I think, a 3-day evidentiary hearing. We went over all the pieces of it that we could find on video, and that is over. The evidentiary hearing involving Lally had to do with the Miles King case, the Brian Walshe case, and wait, let me take a step back. The evidentiary hearing where Lally testified with Rosemary Scapiccio's barbecue was only on the Miles King case. And that evidentiary hearing had to do with Norfolk County DA's office failing to turn over evidence in a timely fashion and search warrants that weren't turned over since 2021. And they were questioning Lally about that. And that ship was kind of abandoned by Judge Krupp. And there's no date set yet for when they have to come back and testify again. So it's a totally different issue, totally different case. These evidentiary hearings are over, and this is only on Brian Walshe. Everybody clear? Here's a brief summary of the relevant facts for those of you who are not familiar, or even if you are, it's a nice little refresh. On January 4th, 2023, police arrived at the home of the defendant in Cohasset to investigate the whereabouts of the defendant's wife, who had been missing since January 1 of 2023. Between January 4th and January 8th of 2023, the police questioned the defendant repeatedly at his home and searched the premises. On January 5th of 2023, police asked the defendant if he would permit them to search his iPhone and an iPad used by one of his young sons. The defendant repeatedly stated that he had to first speak to his attorney, Minor. On January 6, 2023, Minor negotiated an agreement with Beeland to permit the search of the iPhone and the iPad limited to communications only, excluding attorney-client communications, and limited to the time period of December 25th, 2023 and January 6, 2023. On January 6 of 2023, digital devices were turned over to the police pursuant to the agreement. And remember, Fanning said he didn't have him sign the written consent because he thought it would be redundant and there was already an agreement in place. I don't know if Fanning said that or Buchanan. I can't remember at this point. Where is my chapstick? Hold on. The studio lip balm is missing, and that is a problem, but we will go forth and prosper. On January 7th, 2023, the state police began a forensic search of the devices and found incriminating search histories of internet searches on the iPad and location data on the defendant's iPhone. On January 8th of 2023, the defendant was arrested at his home in Cohasset for kidnapping and misleading police. Search warrants were issued on January 8th, 2023, and thereafter for including but not limited to the search of the defendant's home, digital devices, and motor vehicles. So see what happened here. They extracted the phone on January 7th. They got all the information on January 7th. And in fact, was it Garino who testified that, oh yeah, I started finding these incriminating searches. And so I told Tully, and then we just stopped. And then they didn't get a warrant to search the phones until the 8th, but they'd already used all the information that they found on the phones to get probable cause to search the house and the car. I mean, it's like, they've been doing this for I don't know how long, and they've just never been caught. I don't know. This is what they do. And then they backdated it. Yep. They backdated documents al dente. They did. To support the issuance of the search warrants, the applications included specific and detailed reference to the information seized from the search of the two digital devices turned over pursuant to the consent agreement. Evidentiary hearings were conducted on the defendant's motion to suppress based on the violation of the consent agreement on 3 days, May 19th and 20th, 2025, and June 18th of 2025. And that is when we were knee deep, neck deep in the Karen Reed trial. And we didn't cover it then, but we covered it shortly after, or whenever. I'm not really quite sure. Recently. On July 25th, 2025, the trial court issued its rulings denying the defendant's motion to suppress evidence seized from digital devices provided to law enforcement pursuant to the defendant's consent agreement, and denied in part and allowed in part the defendant's motion to suppress evidence seized pursuant to search warrants. Kindergarten cop says, hold on, I got to put this up for you. He says, Garino, if you're watching, I want to be the first one to handcuff you when the feds grab you. You're going to go join are you going to go join the FBI or the MSP or whoever's going to investigate him? Yeah, Trooper Hot might kill me now, Garino. Right, just kill me now, he said on the stand in the Karen Reed's trial. Summary of the law. The search that is based on consent may not exceed the scope of that consent. Commonwealth v. Ortiz. The standard for measuring the scope of consent, quote, is that of objective reasonableness. What would the typical reasonable person have understood by the exchange between the officer and the suspect? The focus is solely on what a typical reasonable person would understand the scope of the consent to be, based on the totality of the circumstances, including the words spoken and the context in which they are spoken. And then he cites the Ortiz case, which in which the SJC held that under both the Fourth Amendment and Article 14, a suspect's consent to search for weapons or drugs in the vehicle does not include consent to search under the hood and under a removed air filter unless it is reasonably clear to a typical reasonable person that consent extends beyond the interior of the vehicle and the trunk. Any ambiguity regarding the scope of the consent must be resolved in favor of the defendant. The police are not allowed to take advantage of ambiguity when they have the ability to resolve it with clarifying questions. Clarity of both voluntariness of the consent and the scope of any consent is required. As a matter of logic and constitutional fairness, the requirement of reasonable clarity must also apply to the scope of consent. And we went over this at length as well. An appellate court accepts a trial court's findings as to the background facts unless they are clearly erroneous and will defer to the judge's assessment of the credibility of the testimony taken at the evidentiary hearing on the motion to suppress. But there must be a valid basis for determining that a witness is or is not credible. And then Larry goes on to say the judge had no reason to not believe Tracy Minor. And here's why. Here's a summary of the relevant evidence established at the hearing. The evidence at the hearing established without contradiction that during the questioning on January 5th, 2023, the police led the defendant, Brian Walshe, to believe that they were interested in communications, and the defendant repeatedly objected to the broad search initially suggested by the police, making it clear he needed to first discuss and get the advice of his counsel, Tracy Minor. The police initially asked the defendant if he would allow us to look through your phone and consent to us downloading your phone and seeing some of the communications between you and her and like her tone. Remember her tone, footnote 2. The defendant did not testify at the hearing, but transcripts of his statements made to police and referenced herein and in the trial court's decision were admitted into evidence. The police then explained that they think it'll help us really create a permanent timeline of the events and maybe get a better insight into Anna, the missing wife. Is that something that you'd be okay with? The police continued, explaining that their intended search would be limited. What we're focusing on, those, is what we're interested in, yes, is download. It downloads everything, but what we're interested in is looking at Anna and finding the information specifically in there that would help us do that to Anna's specific contents. Later, the police stated in part that all we'd be interested in your communication with Anna, and the dates. You know, the 31st and the 1st through present. We're not interested in your other past and issues. And that was Buchanan who had those conversations with him, I believe. Yeah, and he did also question the child, and that was gross. The evidence at the hearing clearly established that the defendant repeatedly expressed strong reservations to the proposed search and would not agree to anything without first consulting his lawyer, Minor. The defendant asked the police, just to be clear, you want to download everything on my phone? The defendant repeatedly told the police he needed to speak to his counsel prior to agreeing to any search, stating in part that Minor had told him that, yeah, you have to talk to me when making decisions, and that the defendant told police he would have to ask her. And again, he goes on to talk about all the conversations that Brian Walshe had with the police, and that he told them that he needed to talk to her, and at least, you know, I can't give you an answer right now. I got to talk to her. She may say no, she may say yes. We got to see. And then Tracy Minor took the stand. Minor testified in relevant part that 1, she consulted with the defendant on January 5th and again on January 6th of 2023 regarding the request to search his device. 2, that she had serious concerns about turning over anything to the police. 3, that she spent 3 to 4 hours reviewing the communications data on the defendant's iPhone and iPad, locating some that were concerning. 4, that she noted at least one communication between the defendant and his wife dated prior to December 25th, 2022. 5, that the police were pressing for consent to search the devices as soon as possible, so Minor limited the search dates to what she had been able to review. 6, that she recalled having 1 to 3 telephone conversations with Buchanan, but did not negotiate any consent agreement with him, and recalled discussing other issues unrelated to the consent issue with the trooper in these calls. 7, Minor testified she needed to speak to the someone in the district attorney's office to discuss consent and was directed to Beland. 8, that the email exchange between Minor and Beland defined the entire consent agreement. That is, communications only, encompassing the time period noted and to exclude any attorney-client communications. 9, that Minor understood the troopers would first do a full extraction, and based on her decades of experience as a criminal defense practitioner and experience with forensic digital examinations, that once a full extraction was conducted, the extracted data would be segregated, and only the data, here the communications agreed to, would be reviewed consistent with the consent agreement. Minor testified there was nothing stated or discussed between herself, Beland, or any trooper that would have permitted the search of all the data on the devices. Minor testified, and Buchanan's report specifically stated the email exchange between Minor and Beland, to which he was copied, was the agreement. Minor testified that the email between herself and Beland established the scope of the consent agreement. The email exchanges on January 6th state in relevant part. So here's the email. Many of you in the chat thought they were ambiguous, but as Larry Tipton pointed out, any ambiguity is to be resolved in the favor of the defendant when you're determining such things as like this. And here it is. Subject, Walshe phone search agreement. Attorney Minor, as requested, the Norfolk DA's office agrees that in the investigation into Anna Walshe, any conversation between the attorney and client Brian Walshe is excluded from the search and examination of Brian Walsh's phone and Thomas Walsh's iPad. It is further agreed that any conversation between Brian Walshe and his wife, Anna Walshe, 1 week before she was missing, 12/25/22 and prior, shall be excluded from the search and examination of Brian Walsh's phone and Thomas Walsh's iPad. Should you have any questions, please contact me, Lynn Beland. That's the email. Then Buchanan's report included the following statement regarding the email agreement. Quote, the agreement was put into writing by Norfolk District Attorney's First Assistant, Lynn Beland. Period. The agreement was then mailed to me, Sergeant Yuri Buchanan, and Attorney Minor. Once reviewed, Attorney Minor contacted me over the phone and agreed to the written agreement, stating that Brian would have no problem turning over the devices on consent. Contrary to the email and Minor's specific testimony, Buchanan testified that his understanding of the agreement was that the consent authorized a search of the entire data on the digital devices, limited only to the time period, and not to include attorney-client communications. Well, that's what Buchanan testified to. His understanding was they could look at everything. Well, I don't know if it would have been proper to point it out in these motions papers, but I'm snarky and I might have. Buchanan also testified in Karen Reed's second persecution that English is his third language, and he doesn't even understand what the word theory means. How could he possibly interpret an email between two attorneys if English is his third language and he doesn't understand what theory even means? He wanted a Webster's dictionary pulled out during his testimony. That's what he said to Alan Jackson. And yet Judge Frenier gave his testimony far more weight than an attorney with, I don't know, 30 plus years of experience. Yeah, Nanya says Beeland left so fast she could have been shot out of a potato gun. Yeah. My ears need to pop. And then Larry Tipton makes what I think is a very good argument. The trial court's application of the totality of the circumstances standard is clearly erroneous and against the weight of all the evidence. And here's what the court said in her decision. Frenier. The court's inquiry is as to what the typical reasonable person would have understood by the exchange between the officers and the consent giver based on the totality of the circumstances. Viewing the entire exchange between Detective Schmidt and Trooper DeChico and Schmidt the first time, right, on December 5th with Brian, and that between Sergeant Buchanan and Attorney Minor on January 6th, a reasonable person would have understood the search as including all the data extracted in that date range, December 25th through January 6th, 23, excluding only attorney-client communications between Brian and Attorney Minor. And I read that out loud to you, and I was like, I'm sorry, what? If Brian Walshe was guilty and he knew that he made those Google searches on his son's iPad, why would he willingly give up his son's iPad and say, go ahead, search for everything? That makes no sense. That is not what a reasonable person would do. And I pointed that out at the time I read that decision, and I was infuriated as usual. And that was at page 25 of the decision. And then the trial court continued and concluded that even if Attorney Minor believed she was consenting to a search only of communications in the devices, the court's inquiry here is as to what a typical reasonable person would understand the scope of the consent to be based on the totality of the circumstances. Citing again the Ortiz case, and the judge goes on to say, based on the overall context of the encounters with the police, in this case, an objective observer would not perceive the search as exceeding the scope of defendant's consent. And we were all looking at each other like, are we all reasonable people? Are we all being gaslit? What is going on here? Is this real life? Are we in Narnia? Is this the land of the lost? And where is Chaka? There's Chaka. This is not a fly on your screen. It's my cursor. So please don't break your TV. Send me a bill. Larry Tipton goes on to say, the trial court's application of the standard is one-sided, discounting what either a typical person in the shoes of Minor or the defendant would have understood the scope of the consent to be, and focuses on Buchanan's recollection. The, quote, totality of the circumstances must include what an objective observer in the shoes of the defendant and his lawyer would have perceived the agreement to be, not just law enforcement. That's what we were screaming into the ether when we read this decision. Number two, the trial court's finding of fact that the email exchange, quote, merely memorialized the agreement between Buchanan and Minor is clearly erroneous and against the weight of the evidence. The trial court stated that the defendant argues that Attorney Minor negotiated the scope of the search with FADA Beeland and that their agreement only concerned communications on the devices. However, FADA Beeland merely memorialized the already agreed to terms of the consent agreement between Sergeant Buchanan and Attorney Minor. And again, I said, are we in the land of the lost? This finding is contrary to the plain language of the email exchange, the direct testimony of Minor, and the relevant statements contained in Buchanan's report, written contemporaneously with the events and questions set forth above. Thank you, Minnie, 560, who points out the obvious. I am all for convicting criminals, but you have to do it within the scope of the law. If you don't, you are no better. Yes. And Brian Walshe could be 100% guilty, and he may be. But searches also need to be lawful and legal. And all they needed to do was to get a search warrant for the phone. And they probably could have, but they just didn't. And is it because they've just been doing it this way for decades? And nobody ever caught him on it until the Karen Reed case brought everything into question and brought all these guys under a spotlight and a microscope and a fishbowl. And it's a slippery slope. Once you start violating people's constitutional rights, they just think they can keep getting away with it and keep getting away with it and keep getting away with it. Number 3, the trial court's finding that in certain aspects, Minor's testimony was not credible is clearly erroneous and is against the weight of the evidence presented at the hearing. Right. The judge just decided, I didn't believe the attorney. I didn't believe Tracy Minor. The Commonwealth did not call Beeland at the hearing. Super important. Why not? I think I know why not, because Beeland was not going to lie for them. She left the Norfolk DA's office so fast after the first Karen Reed persecution. At the same time, David Traub left the DA's office, that she left skid marks. She's not going to fall on the sword for them. The trial court found some of Minor's testimony not credible on the issue of the scope of the consent agreement. Quoting again from the judge's decision. More specifically, the court does not credit Attorney Minor's present recollection that law enforcement examination of the extracted data was limited to communications between Brian and other persons for the period of December 25th to January 6th. That recollection, more than 2 years after the interactions in question, is contradicted by and inconsistent with other evidence that the court finds more reliable and believable. And again, when we read this decision, Chaka, help us. We're in the land of the lost. You believe Buchanan and you're just going to disregard the attorney's testimony? She's been an attorney for decades. It made no sense. It made zero sense. This finding is without sufficient factual support and applies factors minor and disregarding similar factors with regard to Buchanan's testimony. First, the passage of time, if it applies at all in light of the uncontradicted and direct testimony of Minor, applies with equal force to the testimony of the Commonwealth's witnesses, specifically Buchanan, and as set out summarily above. Minor's testimony was detailed, reasoned, and specific without inconsistency. Secondly, the trial court does not discuss the inherent inconsistency of Buchanan's report and testimony that includes the specific fact that after speaking with Minor on the telephone, that Buchanan provided Minor with Beeland's contact information. And Minor clearly testified in detail that she negotiated with Beeland, not Buchanan. It begs the question then, if Buchanan negotiated with Minor, why would Minor want to speak to a prosecutor, be directed to Beeland, and then exchange emails with the agreement directly with Beeland? Yes, this is the same judge who said she had a potential conflict of interest. Yes. So this judge said, thank you for pointing that out. That is true. DK94, paying attention. Judge Vernier said, I have a conflict with regard to the Michael Proctor communications issue because the attorney, I think his name is Sullivan, that the Commonwealth has hired to represent them in the federal proceeding to get Proctor's communications in this case, the King case, and all the other cases, was a mentor of mine. So I can't decide that issue. But she didn't recuse herself from the rest of the case. And that is why Judge Krupp in Norfolk County is hearing the issue only on the comms with Proctor and whether they're going to be turned over to all of the attorneys in those cases because the feds wanted them to be destroyed. Third, while finding Buchanan's testimony credible and not adversely impacted by the passage of 2 years' time, as the trial court noted Minor's testimony was, the trial court did not address another inconsistency in his report. His report, are you shocked? Misstates the terms of the agreement at the outset, and contrary to the agreement, terms in the email exchange between Minor and Beeland, that is, that the devices to be included in the consent agreement would include the defendant's cell phones, and his minor children's cell phones and tablets. But the agreement negotiated between Minor and Beeland and embodied in the email exchange only included one of the defendant's cell phones and one of the children's tablets. The trial court's finding that in certain aspects, minor's testimony is not credible is not supported by the weight of the evidence and is clearly erroneous. 4, the trial court, relying in part on Buchanan's memory, and discarding the detailed testimony of minor and the evidence discussed above that the email exchange was the agreement, went outside the plain language of the email exchange to conclude the terms and the consent, the terms of the consent, and resolved any apparent ambiguity and lack of clarity in favor of the Commonwealth. Notwithstanding the fact that the trial court had to go outside the plain language of the agreement encompassing the email exchange, the trial court found no ambiguity. In doing so, the trial court wrote that it is certainly true that the requirements of reasonable clarity applies to the scope of consent, and that if the court is unable to discern the scope of the consent because the agreement was ambiguous, then the search should be deemed unlawful. The trial court went on and found there was no ambiguity with regard to the scope of the consent. So if there was no ambiguity, then the search should be deemed unlawful. And he goes on to explain that in length. In a 24-page application. Here's a footnote that I skipped that said here. The trial court refers to the testimony of a second state trooper, Lieutenant Fanning, in supporting the court's decision. Importantly, Fanning's sole involvement was to pick up the devices on January 6th of 2023, since Buchanan was unable to do so, right? Because they flew him to DC, right? To meet with Anna's lover. And it was her lover, because he admitted to being her lover. So it's not alleged lover. At the hearing, it was established that 1, Fanning did not write a contemporaneous report with his role on January 6th of 2023. 2, Fanning only drafted a report regarding his January 6, 2023 events in May of 2025. Remember? Right before he testified, he wrote the report and backdated it because that's what they do there. And 3, that Fanning dated this report as if it were written in 2023. It would only be fair and just to apply the same passage of time factor applied to minor to both state troopers who testified. Because you can't make it up. You just can't make it up. And then he goes on to argue why there would not have been inevitable discovery because Proctor used the illegally obtained evidence in the probable cause affidavits for the search warrants. And once the illegally obtained evidence is excised from the affidavits for the warrant applications to search the devices, they fail to establish probable cause for an all-encompassing search. And they are asking after a lot of argument, he says, here, the trial court made the same clearly erroneous conclusion in the present case, evidenced by the summarily stating, quote, evidence of the same could be found on the phones without any particularity. Here, there is no particularity or evidence establishing a nexus to such an unfettered search of the digital devices, namely a search of the browser history, especially prior to January 1, 2023, or location data, especially past January 1, 2023. He then goes on to say, the trial court incorrectly applied a bad faith requirement to conclude the evidence illegally seized as a result of the consent search would have been inevitably discovered. Importantly, there is no defined good faith exception, or conversely, a bad faith exception or rule for police extending the scope of consent to either justify or excuse such behavior. And it is a very well-reasoned motion. And in closing, Larry Tipton says, administration of justice. Pursuant to the order regarding interlocutory appeals, the defendant states that the administration of justice would be facilitated by a grant of leave to appeal to correct the errors of law and fact in the trial court's rulings. An appeal would prevent the admission of substantial evidence illegally seized that would result in the violation of the defendant's rights to a fair trial, due process in Article 14. And he's right. If all of this evidence is not suppressed and they go through the entire trial and he is convicted, that's the problem. And so it is the proper time to hear this appeal now and have the appellate court decide on whether this needs to be sent back, whether the evidence needs to be suppressed before the trial happens. An appeal would permit clarification of the applicable law on the issue of consent specific to the standard to be applied in determining the scope of consent. That is, in what a person would have believed the scope of the consent based on a totality of the circumstances and the application of the rule of clarity. Finally, granting the defendant's interlocutory appeal would permit an exacting analysis of the application of the principles regarding inevitable discovery and whether bad faith on the part of law enforcement is required where there is a search exceeding the scope of any consent. The present record of the issues is well established factually, and the issues presented are ripe for review. Accordingly, an interlocutory appeal would preserve judicial resources in preventing 4 to 5 weeks of trial, an additional time, and difficulty in selecting a jury in a case receiving substantial publicity. The defendant requests that his application to proceed by way of interlocutory appeal be granted and the proceedings in the trial court be stayed to permit the issues to be briefed and argued. XOXO. This trial is slated to take 3.5 weeks, I think, to 4.5 weeks is what he says somewhere in the papers. Hang on one second, because I think he also said, I think that the trial date is definitely scheduled for October. And so if the SJC decides to take this, it would stay the case until there's a decision and the trial will be delayed. I don't know how long it takes them to decide whether or not they're going to take it. So if anybody in the chat is a practicing Massachusetts attorney, you can tell me. But we know in the Karen Reed trial, those appeals took a long time. They took a long time. But perhaps, maybe, in this case, they would get it done quickly. Brian Walshe has been in jail in Norfolk County Pokey since his arrest in January or early February of 2023. Same jail where Aiden Carney was held. Aiden sent him a note and said, do you want to talk to me? And he said he couldn't. And he gets his hair cut with a hammer by Elsie the barber, who we found out does a $5 haircut in the Norfolk County Pokey and was an inmate there as well. But he was transferred to LC. And so LC gave the haircuts to Brian Walshe and Harry Turk. And we had some fun with those. There's a fly. Thank you to Kyle, who just sent me this, that this also has been docketed in the SJC. They've been granted a fee waiver because it costs money to file these appeals, costs money to brief them. And all this was filed in the SJC on the 25th of August, and the fee waiver was allowed. But I seem to remember in the Karen Reed case, the one judge decision was relatively quick, and then it was the full panel decision that took a lot longer. But there were so many appeals in that case, state appeals, federal appeals, and I might be conflating. I think it's a good issue. I think it's ripe for appeal. I think they went outside the scope of the consent, but that's been my opinion since the beginning. Her body has never been found, but allegedly there was a piece of bone found on a hacksaw. Oh yeah, because when they got his location data illegally, outside the scope of the consent, they also found some video at a dumpster. They found him putting stuff into a dumpster, and most of the dumpsters had already been incinerated. But in one of the dumpsters, they did find a Tyvek suit on a Walshe's vaccination card, a Prada, I think it was a Prada purse. And the Tyvek suit had, I think, his DNA on it, and maybe Anna's DNA on it. Don't quote me on all the details right now. But again, fruits of the poisonous tree means that if you got there illegally, all that stuff gets suppressed. And maybe there was a fragment of bone on the hacksaw that they got video of him buying. Maybe. We don't know if it was tested. We don't know if it was hers. There's so much more to this case that we just don't know. This is a lot of evidence that we don't know about yet. The question is whether they obtained the evidence illegally, and if so, should it be suppressed? And if all that evidence is suppressed, do they have enough to convict Brian Walshe? I don't know what happened with Proctor's text messages because we couldn't watch the hearing Thursday because we were watching Howie Carr's interview, and then I had the Zoom up at the same time. Does anybody know what happened at that hearing? It was quick because when we went back to watch it, it was over. So let me see if I can find out what happened at that hearing quickly. If anybody knows, you can just tell me because that hearing was Thursday. Let's see. It was a 20-minute hearing. Thank you, Dizzy. Thank you so much. I'm dizzy right now. It was a 20-minute hearing, status set for 9:15. They will get the results by email. Thank you so much. Thank you. Thank you so very much. Appreciate you. You guys are great. You're the best. Alicia, thank you for your 5. Says, enjoy your show. So engaging. And I learned so much with your remarkable intelligence, witty nature, humor, energy, beauty. Oh my God, girl, compliments will get you everywhere. Thank you so much. Thank you so much. You're very, very sweet. I love you with all of my heart. Thank you, Mama Shee, for your super sticker. I also love you with all of my heart. Sherilyn for your Cash App yesterday. Thank you. Sophia says, please donate to Kelsey's GoFundMe. She needs our help. I don't know if I've linked it yet in the show notes, but I will. I will. If I can link it, let me find it. Let me find it right now because we're here and Kelsey does need our help. And she is very appreciative for all of you donating. Hang tight for uno momento while I find it and I'll put it in the chat. Mm-hmm. Okay, hold on. I will read to you where the money is going. and pin it in the chat. Yeah, and this is always a problem when I try and do this because you can only pin it from your phone. And then when I click on it with my finger, it takes me instead to the link, and then I can't pin it. Oh, now I can. Okay. There it is. Okay. I did it. I did it. I have big fingers, I guess. Or my phone is too small. Maybe I got to enlarge the font to like 75. Here's the, let's take this down, put this up. Here is the give, send, go to help Kelsey heal. It is pinned in the chat. It has raised $5,875. It says, Kelsey is a caring, devoted mother who has always put her baby boy first. I know that the first time we put this up, you guys raised about $4,000 because you're amazing. You're amazing. And I know some more stuff, but I'm not gonna talk about it. Kelsey is a caring, devoted mother who has always put her baby boy first. Kelsey's baby boy is only 4 months old, and he is her pride and joy. This was about a month ago. The baby is a little bit older now. Kelsey has unfortunately been battling with postpartum depression and has done and is doing everything she can to heal and recover. In the process of healing, Kelsey was met with a mother's worst nightmare, having her baby taken away from her while being served a restraining order full of false narratives and self-serving allegations. During this already extremely tragic incident where she needed compassion and help, she was met with deadly force and a gunfire to her chest. She has undergone multiple surgeries due to her injuries, and she has a long road to recovery as she sits in the hospital today. She now needs extensive support to heal physically and emotionally. We are raising funds to help cover a variety of expenses, such as Kelsey's household bills while she's unable to work, and to assist her parents as they take time away from their jobs to care for her full time. Your donation will go directly toward household bills and living expenses, medical costs and therapy for her recovery, travel and time costs for her family so they can be by her side and support her, experts, investigators, and legal incidentals. Every dollar helps Kelsey get closer to healing and having the healthy future she deserves. Thank you so much for your kindness, generosity, and compassion during this difficult time. Please share if you can. And everyone's donations are anonymous, so don't feel like you can't give because you don't want people to know that you're giving. I guess on Give, Send, Go, you can do a setting where everything is anonymous, and probably based on the hot button issues in this case, some people, it's better if whoever donates, maybe they're not made public. There is one other thing here. I want to bring to you. Let me just download this. And these are the conditions of her bail. So her conditions after the 8/28 hearing, after a home visit and a BW, it says hearing held on 58A, that's dangerousness. After a home visit and a BW, court will issue the following conditions. 1, bail to be set at personal recognizance. That's amazing. 2, GPS, do not release. Bail cannot be posted until GPS is in place. So they're going to do a home monitor, an ankle monitor. 3, 24/7 house arrest except for medical court attorney visits with 48 hours notice to probation. 4, reside with her mother and stepdad at their home. No weapons in the home. And Corey checks on all people in the home, which are criminal background checks. Stay away and no contact with the victim or with her child. That's a term of her probation as well. No alcohol with Scram. I guess is that another monitor? Sign any and all releases and follow treatment plan by MGH. Some of you can interpret that for me for a second while I take a spoonful of honey to fix my vocal fry. Hang on 1 second. I'll be right with you. Talk amongst yourselves for a second. Actually, you know what we'll do? A scram is an alcohol monitor. Thank you. Took her baby away, just Rhonda, because her baby daddy, who's a firefighter, went in and said she's a danger to the baby and herself. And she's not allowed to see her baby. For those of you who say you haven't been caught up on her case, I have a whole playlist on it. I will link it below. You can go back and get caught up. But the good news is the grand jury did not indict on the attempted murder charge. Yeah, she should get supervised visits, says Carrie. Not seeing my baby would kill my will to live. That's what happened. They took her baby away. She says she was suicidal. She didn't point the gun at the officer. She pointed it at herself. She's been, nope, not even supervised visits. No visits. I'll pull it up for you. Hold on. Except I just need to redact it. So hang on for a second. And you can look at it and read it while I get the Manuka, honey. Well, I don't want to do it because it names her mother and her stepdad, and their names don't need to be public. So there's that. But in the interest of ending this on a funny note, no supervised visits, no visits at all. Nope. There was a witness. There was a witness. Thank you, Dee, for becoming a new member. D. Nice Law. And Kat Randall for gifting a membership. Thank you, sweetie. And also, Boston Girl gifted a membership. You're awesome. You're all awesome. Let's take a look at the AG, shall we? The AG. For those of you who are not familiar with the AG, Devon Flanagan, you're in for a treat. This happened, I don't know, around August 15th or 16th in Newport, Rhode Island. And this AG has been suspended without pay. And she was arraigned, I think, yesterday. But before we do that, it's only 6 minutes and 20 seconds long. For those of you who have not seen the body cam footage of the date in question, Devon Flanagan and her friend were arrested outside of a Newport restaurant on August 14th. And it was caught on body-worn camera. And this is the epitome of "don't you know who I am?" It was on outside the Clark Cookhouse restaurant in Newport PD. And here's the Newport PD body cam footage. If you haven't seen it yet, it's a treat. But if you have your kids in the room, put earmuffs on because there's a couple of F words in here. But in order to give it its full effect, you kind of need to hear everything she says. The volume doesn't start for a minute or two because it is body cam. And this is, again, Newport PD, Rhode Island. ShamWow says he's happy to have me in his ear for a year. Unlike Dan. Poor Dan. Just listen for Dan and watch the girl in the red dress. And I'm going to be right back.
I want you to turn your body cam off. Protocol is that you turn it off. If a citizen requests it to turn it off.
So they want you guys to leave?
Yes, we're gonna leave.
Let's just leave. Let's just make it easy,
We're gonna
okay?
leave. We're gonna make it easy. That's not.
I am. Okay. I'm her
That's
husband.
not the point. Can you look at me?
Yeah, we'll talk over here, okay?
Your protocol is.
Can we all talk? Can we all talk? Talk over here. They want you to leave.
Your protocol is.
Can we talk? Who's she to you?
What's that? No,
Who's she to
nothing
you?
happens. Nothing.
She is our college friend. Okay. Yes.
No, I'm not.
You guys just want to know? Do you want them trespass? Anything we can do. Trespass, yeah. I just need trespass. Get it out. Please.
No, I'm not.
Shout out to the maitre d' of the restaurant or the bar or whatever it is. outside who's like, I just want them out of here. He's like, do you want them trespassed? Meaning charge them with trespass. And in fact, she does not make it easy. But shout out to that guy. Let's take it back a minute. Because he's like, please just get them out of here. They're causing a scene. Nothing worse than entitled drunk girls. Emily C. will narrate this for us. Narrator, she in fact did not make it easy. I'm her husband. I'm sure he is ashamed to have had to admit that now that this has gone viral worldwide.
You guys just want to know, do you want them trespass? Anything we can do. Trespass, yeah. I just need trespass, get them out. Please.
No, I'm not. No, I'm not.
Do you want to chat?
I know that your protocol is.
So you're trespassing, so we got to leave now. Unless you want to be in there.
We're not trespassing. You haven't notified us that we're trespassing. Number one.
What did I just say to you?
Number
Let's go.
one. Number one.
I don't want to
two,
arrest you guys.
You're not going to arrest us. Number two
So let's
is
leave.
that
We got to go. We got to go.
protocol
Let's go.
is
Let's
to
go.
calm down for 1 second. We ask you to turn the body
I don't
cam
want to deal
off.
with this. Let's
Okay.
go.
No, I understand you don't want to deal with it, but
Oh my God. Oh my God. The way that the friend, Veronica, okay, so the AG is in red, okay? The way that the friend goes, she's like, talk to the hands. Excuse me, I have a Chloe bag. Do you know who I am? It is outrageous. Everyone show this, please show this to your children. Your protocol, excuse me. It is free entertainment, I know. It's not a real protocol, I don't think. He says, I don't care.
going to arrest us. Number two
So let's
is
leave.
that
We got to go. We got to go.
protocol
Let's go.
is
Let's
to
go.
calm down for 1 second. We ask you to turn the body
I don't
cam
want to deal
off.
with this. Let's
Okay.
go.
No, I understand you don't want to deal with it, but the
let's go.
protocol is, and your protocol is if I ask you to turn off the body cam, you have to turn it off, and that's your protocol.
She's a fucking lawyer, so she knows.
Well, that's bullshit lawyer stuff, so that's not true. So we got to go.
No, it is. That's law.
I'm an
What do you
AG.
think?
I'm an AG.
Good for you. I don't give a shit. Let's go. We're going. Let's go.
Excuse.
We're leaving.
Please don't
We're leaving.
put your hands on us.
Can you guys?
Good for you. I don't give a shit. I mean, let me know if you think they were like unnecessarily roughing them up a little bit as we get into this a little bit more. But he's having none of it. And I bet you, oh my God, in Newport, they probably deal with this 10 times a night. Fair use. I got to keep stopping it. Sorry, guys.
Children out of here. Like, I don't know why.
Okay, if you didn't hear that, it goes, get your children out of here to the husband. Get your children out of here. Oh, and then they really start getting mad.
For you. I don't give a shit. Let's go. We're going. Let's go.
Excuse.
We're leaving.
Please don't
We're leaving.
put your hands on us.
Can you get your children out of here? Like, I don't know why.
I'm sorry. What?
Let's go.
Let's go.
Let's go.
They're two full-grown women and mothers.
You're just being detained. You're just being detained.
I'm an AG. What do you probable cause to detain me for?
You're being detained because you're not leaving.
Because I'm what? You have
Can you relax? Sir, she's not doing anything wrong. She's not leaving.
I'm an AG.
She's an AG. Honey, you're not. She's not being arrested. Let's go.
I'm not.
She's an AG. She's an AG. I'm an AG. I'm an AG. Why not just leave? Why not just leave? Wait till you see what the other one does. What do you see? Think this is bad. What do you see what the other one does?
Being arrested, you're putting me in cuffs. I'm not being
Okay, do you have any
arrested.
weapons on you?
No, I'm an AG.
Her badge is in the car. You want to go get a badge?
Let me tell you something. You're arrested.
Get the hell out of here. What are you just seriously?
No, arresting an AG. Let me tell you something.
You want to arrest her?
You could hear the friend screaming in the background. No, listen. I think her name's Veronica. Listen to Veronica. You can hear her screaming in the background. And it's crazy.
You want to go get a badge?
Let me tell you something. You're arrested.
Get the hell out of here. What are you just seriously?
No, arresting an AG. Let me tell you something.
You want to arrest her? Like, no.
You're putting me in handcuffs and you're Mirandizing. You're not Mirandizing me.
Relax.
Buddy, you're gonna regret this.
Yeah.
You're gonna regret it.
Buddy, you're gonna regret this, buddy. You're gonna regret this. Oh boy. Oh, Nick Soro's here. He's rating us. Hi, Nick. Hello, Nick. Thanks, Nick. Thanks for coming on over to watch the AG. And we're gonna watch her arraignment after this. The only thing to her credit that she did right was to get in the car and put her feet in the car without, unlike her friend Veronica. You're gonna regret this.
How many?
Wait, that was my favorite part. I'm an A, and then he slams the door in her face. That is my favorite part. Watch it again for funs.
You're gonna regret it. How many?
We will get the license.
Stop your hands off me.
We will get the license.
No.
No. We will get the license.
Get out of here. Get back right now. Get back.
I'm dying. With the Chloe bag, I'm dying. And then she has a near nip slip. Watch. I didn't notice this the first time I watched it. She weasels her way out of the cuffs. She gets out of the cuffs. This girl should be a magician. Watch this. They cuff her, and then she's able to get out of them. Look at this. Watch.
Get a team.
No, I can't. No.
Get back.
Your cuffs.
Yep.
I'm right here. It's okay.
Just go from
I'm
the
right
car.
here. No. I'm right here. Come on.
He got out of the cuffs. Did you see it? Okay, that's Dan, the husband, and he's like, I'm right here. She got out of the cuffs. Did you guys notice that before? Watch this again. She's Houdini. I was focusing on Dan.
Your cuffs.
Yep.
I'm right here. It's okay.
Just go from the car.
No. I'm right here. Come on, babe.
No.
And there was the very near nip slip where her dress almost fell off in front. And she probably is not wearing a bra underneath that. Maybe she's wearing the nip covers, but watch that again with the near wardrobe malfunction. But the getting out of the cuffs thing is crazy. Watch it all without me interrupting. Here we go.
I'm right here. It's okay.
Just go from the car.
No. I'm right here. Come on, babe.
No.
All right.
Babe, I'm right here.
No, babe, please, I'm scared.
I'm right here.
Please, up to this. Please, up to this. No, I'm not going to find no one after.
I'm right here.
No.
Okay.
No, please, up to this, my friend.
I'm right here.
No,
Right
no,
here.
no. Babe,
I'm right here.
babe.
I'm right here.
No, babe.
Relax.
No,
Relax.
What's wrong with you?
Relax.
We don't want to put you in handcuffs. Let's go. Let's go.
No, babe.
Cop says, what's wrong with you? All they had to do was leave.
Babe.
Listen, you're overreacting. You're adding charges. You're overreacting.
No. Please take my hands up. Please take your hands up. No, please.
You were overreacting. You didn't have to have this happen. Get in the car.
No.
It's
Babe,
bad.
no!
You got 2 to 10.
I'm right here.
It's right
Get
there.
No!
Just put her in.
No!
Get back, bro. In the car.
No!
Get your feet in the car.
I'm right here.
No!
Get your feet in the car.
No!
Get your feet in the car.
Dan!
Babe, I'm right here.
No! Babe! Babe! No!
Get your feet in the car.
Who the fuck are...
Get
Don't
your
touch
feet
me!
in the car. You're a grown adult. You're acting like a kid.
Dan!
Poor Dan. Do you think Dan has filed for divorce yet? Dan. She did it to herself. She lost her shoes. in all of this. And they could have broken her foot. They could have slammed her foot in the door because she's being a drunk idiot. Cass Pajama saying, no, they didn't use excessive force. Excessive force. Imagine dealing with this BS every day. Oh, she'll probably file a lawsuit, don't you think? I'm sure she has some bruises and she'll file a lawsuit. But this body cam footage is going to sink her. Civil lawsuit for the injuries she probably claims to have sustained during this. But Dan is Dan filming it for the divorce? I don't know. He doesn't need to because here it is right here. Dan can use my footage, unlike the Daily Mail. Wild. Dan was excited for a quiet night at home alone. He's like, okay, bye-bye. Bye. See you later. Again, I'll bail you out in the morning again.
Get your feet in the car.
No!
Get your feet in the car.
Dan!
Hey, I'm right here.
No! Babe! Babe! No!
Get your feet in the car.
Who the fuck are... Don't touch me!
In the car. You're a grown adult. You're acting like a kid.
Dan! Dan! No! Who the fuck are you? This is so inappropriate! You're overreacting!
So, they wanted to trespass. And they were just throwing a fucking fit. So, we've got 2 to 10.
Well, here's Devon Flanagan. You might not recognize her in navy blue instead of the red dress, but she was arraigned yesterday in a Rhode Island courthouse. Let's see where this was. Well, actually, I'm sorry. It was 3 days ago, but I was sick and we were dealing with other things, and it was Wednesday. Today's only Saturday, so we're not too far behind on it. This was at the 2nd Division District Court in Rhode Island. Special Assistant AG Devon Hogan Flanagan. She's not an AG. She's a Special Assistant AG. You lie. You lie. Can you say maybe you ought to think about stop drinking? Here we go. Here she comes, Devon Flanagan. Proud graduate. Somebody said, where do you think they went to college? Salve Regina. And I did look, the other day when I was falling into my rabbit hole, I think she went to Catholic University, and she was a soccer player. So yes, Catholic girls at the CYOO. You know how the rest of that one goes. She's 5'5", according to her statistics from the 2012 women's soccer team at Catholic University. She was put on unpaid leave a couple of days ago. We did cover that, but we did not have the pleasure of covering her arraignment in which she pleads no contest. Here we go.
Right, this is case 2155, 531. Ms. Hogan, is your date of birth 1/1991?
Yes, good morning, Your Honor.
And are you residing at 210 Sharon Drive? No.
Yes, Your Honor.
All right, counsel, we have one charge of trespass. How does your client wish to plead?
Judge, I did submit a plea form, nolo contendere, with her permission, please.
All right, detective, swear the fact?
I do, Your Honor.
All right. So, just get all my documents together. So, ma'am, you have submitted a request to enter a plea of nolo contendere, is that correct?
Yes, Your Honor.
Do you understand that a plea of nolo is the same as guilty, same as I did under our case law?
Yes, Your Honor.
And in doing so, you're waiving your right to a trial. You know what a trial is, right?
Yes, Your Honor.
You're waiving your right to a trial before.
It would have been so much better if he said, you know what a trial is, right? And she said, I'm an AG. I'm an AG. I'm waiting for the whole time to say, I'm an AG. A plea of nolo in Rhode Island is apparently the same thing as pleading guilty, which is interesting. It's not the same in every state. So I interrupted it. So let's take it back because I just really wanted her to say, I know what a trial is. I'm an AG. I'm an AG.
Detective, swear the fact?
I do, Your Honor.
All right. So, just get all my documents together. So ma'am, you have submitted a request to enter a plea of no low entry, is that correct?
Yes, Your Honor.
Do you understand that a plea of no low is the same as guilty, same as I did it under our case law?
Yes, Your Honor.
And in doing so, you're waiving your right to a trial. You know what a trial is, right?
Yes, Your Honor.
You're waiving your right to a trial before a judge sitting with a jury or a judge sitting alone. You're waiving your right to require the prosecution to prove each and every element of this charge against you by proof and evidence beyond a reasonable doubt. You're waiving your right to presumption of innocence, your privilege against self-incrimination, your right to confront and cross-examine all witnesses against you, present evidence of witnesses on your own behalf, testify should you choose to do so. You're waiving your right to appeal any decisions the court makes or sets. So you're giving up all your trial rights. You understand that, right?
Yes, Your
Do
Honor.
you have any questions?
No, Your
All
Honor.
right, the next set of questions I ask everyone who can offend. Are you currently under the influence of any medication, drugs, or alcohol that might affect your ability to make this decision today?
No, Your Honor.
And you understand if you are not a U.S. citizen, a criminal sentence can have immigration consequences.
Yes, Your Honor.
All right, listen to the act.
Thank you, Your Honor.
On August 14, 2025, the defendant did trespass at the Clock Cookhouse, 24 Bannister's Wharf in Newport, Rhode Island.
All right, after hearing those allegations, do you agree that the charge can be proved beyond a reasonable doubt?
Yes, Your Honor.
Is there anything you'd like to say?
No, Your Honor.
All right, so I'll find a factual basis for your plea. I'll find it's knowing, intelligent, and voluntary. Mr. Hagan, what's the agreement between the parties?
Your Honor, it's a 6-month filing, no return to the Cookhouse restaurant, and court costs would be imposed.
All right, filed for 6 months, no return. Clark Cookhouse, court costs, ma'am, you sign the clerk, you're all set.
Thank you, Your Honor.
Thank you.
So that's what she got. 6 months, you got to stay away from the restaurant that tried to kick you out. She's happy. It's a guilty plea. I'm assuming it's a misdemeanor. It's trespassing. As an attorney, if you're convicted of a felony, you lose your license automatically. In most states, I would imagine. I know in New York you do. Or at least you're suspended and then you have to try and get it back. Slap on the wrist, stay out of there. And she's still got that entitled smirk on her face. And the judge sounds to me like a New Yorker. Didn't he? Like, you know what a trial is, don't you? Cupcake. Cupcake, you know what a trial is, don't you? 6 months. Don't go to that place, all right? You come back, you think, well, bada bing, bada boom, bada bing, bada boom. She's on unpaid leave. I don't know for how long. Living with that video, living with the video out there is the worst punishment she got, says Nikki. You're right. What about her friend? I don't know. I want to know about her friend. Because at least she was cooperative. But look at her, getting the last smirk in there.
Hey, can I see you for a second?
Yes.
No alcohol-related charges. He's no cupcake.
I know I saw it from me.
But her hair and makeup is on point for this this courthouse, for this court appearance. And also, I want to point out there's some screaming going on in the background. Many of these courthouses hold prisoners down below, and oftentimes you can hear them screaming and tantrums coming through the vents. And that's what it sounds like. And then she looks a little bit scared. Did they keep her overnight until the next day, until they had to arraign her? Probably. I would imagine, right? But I really am dying to know. So take it back to see her hair and makeup on point and her smirk, and then the screaming from whoever's downstairs.
I know I saw it from me. Spencer Wine.
Well, Maria, that woman's boss tells me that he was trying to get answers this summer about all of that.
That was that. So if she stays out of trouble for 6 months, the whole thing will just be dismissed. And that arraignment was on Wednesday. I've never heard it called a 6-month filing, which that in New York, I think it's an ACOD, where if you stay out of trouble for a certain period of time, then it comes off your record and you get out free. A 6-month filing in Rhode Island means the case could ultimately be dismissed if she stays out of trouble. She was also ordered not to return to the Clark Cookhouse, where she was arrested on August 14th. She's 34 years old, and she's a mom because that's what Dan said. They're mothers. They're mothers. Flanagan's attorney declined to comment Wednesday to Boston.com. And her plea agreement comes just days after Rhode Island Attorney General Peter Nerona placed Flanagan on unpaid leave for 6 months. You guys are right. Unpaid leave for 6 months. And encouraged her to reflect on the seriousness of her conduct and make corrective changes. Maybe she'll, go to rehab. I don't know. Maybe she should. Not a good look. Being that her kids are going to pull that up on the internet forever. It's out there. Hannon. Okay, so wait. Let's see what happened with Victoria. I'm sorry. It's Veronica. Did I call her Veronica before or Veronica? Veronica Hannon, Hannan, in case you want to Google her, 34 years old. She also was arrested. She was also arrested on charges of disorderly conduct, willful trespassing, and resisting arrest. So Veronica caught more charges. She also entered a plea of nolo contendere on the resisting arrest charge Wednesday, and prosecutors dismissed the 2 other counts against Veronica. Well, I guess the don't you know who I am thing really kind of played out in their favor, didn't it? Like Flanagan, Hannon was ordered to stay away from the restaurant and was given a 6-month filing. Today was Veronica's first opportunity to take responsibility for her conduct. And she did just that, said her attorney, John Grasso, in an email. Veronica admitted to resisting a lawful or unlawful arrest, and the court filed the matter for a period of 6 months. Veronica apologizes to the members of the Newport Police Department for her reaction to being taken into custody. That's an interesting wording of the apology, right? Something a true narcissist does is they apologize. They don't apologize for their behavior. They apologize for the reaction to their behavior. Or maybe they gaslight you into thinking that you overreacted to their behavior. And so let's look at the actual wording of this apology on the screen, because this is interesting. She doesn't admit that she did anything wrong. She just is saying right here. Veronica apologizes to the members of the Newport Police Department for her reaction to being taken into custody. Her behavior and her reactions occurred before she was ever even taken into custody with she's an AG. She's an effing lawyer. So there's that. I'm sorry you're so upset, right? Not even sorry. Apologizing only to the Newport PD for her reaction to being taken into custody. She's not apologizing to the restaurant that she has to stay out of for 6 months for causing a ruckus and perhaps losing business for them. Although now I think everyone should go support this restaurant. What's it called? The Cookhouse? Go there, support them, because they're not going to put up with drunken a-holes like these two disrupting their business and their patrons. Clark Cookhouse in Newport, Rhode Island. ShamWow says, lesson to dating people, know them at their worst. Thank you for your super chat. And Chrissy Mel says, imagine how drunk you must be to get tossed in Newport. Thank you, Chrissy Mel, for your super chat. And Bridget says 6 months, no pay. Thank you so much, Bridget. She was 6 months, no pay. Will they take her back? Will they take her back? Yeah, she's been ordered by the court to stay out of that restaurant for 6 months. Well, at least she tried, right? At least she tried. What is this, Tiffany, that just sent me? Oh, thank you. Thanks, Tiff. When is this from? All right, so it looks like yesterday. No, the 27th. Today, what did I say today was the 30th? So this was the other day in the Walshe and all those other matters. The Commonwealth made a motion to restrict the dissemination of the federal court orders. I don't know if I already went over this one, Tiff. Thanks for sending it to me, but I have to digest it more before I can do a cold read online. This has to do with turning over the Proctor test messages. I gotta go. I gotta go. Stace, I gotta go. I got a thing. I gotta go. Thank you all for coming to hang out with me for a while today. I appreciate you so much, more than you know. I am going to be traveling for the next couple of days with another college drop-off. New apartments for everyone. Moving off campus. Very exciting time. And so therefore, I will have my equipment with me. I don't know how often you will see me for the next few days. It is a holiday weekend also, but you never know. So you're going to want to make sure that you have all your notifications scheduled and you're going to want set and that you're going to that you're subscribed and that YouTube didn't randomly unsubscribe you or some stupid stuff like that, because they've been doing that lately too. And you're going to want to do that because sometimes I go live without any warning. And so we're going to see what goes on in the next couple of days and whether or not I have the opportunity to. And you know, I always do. If I can, I will. Thanks for hanging out with me today. Thanks to the moderators for keeping it classy. Do all the things that YouTube likes. Please like the stream, share it out. Do all the things. I can't. I'm getting over it. It's finally going. Hopefully it won't continue for much longer. Stay cool, stay kind, stay classy. You're the best. I love you with all my heart. If I don't see you soon, I'm going to die. Replay viewers, smash the like as well. Thanks, you guys. Peace out.